Lord, may I have your kind leave to mention item number 566 of today's list, my lord. An order was passed by your lordship on April. It's in relation to non-consideration of my application under section 14. There's a directive given upon the DM Bardhaman to dispose of my application which is pending for more than 1 year. Now, my lord, though the hearing has been took place since May, the order has been reserved and numerous opportunity has been given to the guarantor even under proceeding under section 14. I've taken out an application seeking clarification.
Clarification.
So clarification and further direction upon the DM that there is no need. It's an administrative work under section 14 minor. The borrower didn't even get a chance of audience in that application under section 14 of the Surface Act, my lord.
Who are you?
My lord, I am the NBFC, my lord, I'm the lender, my lord.
Yes.
My section 14 application, my lord, 30 days.
So what clarification of the
My
order?
lord, the order has not been complied. The order has been reserved since May
Yeah,
2020.
then it's a contempt. Why will a
Lord,
clarification?
my lord, I
application
do
come?
not want to take the trouble of like making a contempt allegation of contempt, my lord. The only thing is he's failing to understand there is no chance of giving any audience to the borrower concern, my lord. To that extent only, I'm
Nothing. Let it remain where it is.
Permitted to mention two matters for upgradation. The
No,
petitioner
please
has
don't.
challenged the Revocation Act, Your Lordship, Incentive Revocation Act.
Incentive
Lordship-
revocation, then give. Next week, the other one. Tuesday.
Lordship, under compelling circumstances, I mentioned. Lordship, it is not for application or inclusion. Lordship, actually, this order was passed on 29th August by your Lordship, and the matter has been made returnable on 23rd September. It has not been finally disposed of. I approached the department for a certified copy of the order on 29th August. The department is saying that without the leave of the court, they cannot have the file in their hand and give the certified copy.
Where is the file?
It is, according to them, it is in the court. It must be in the court.
Give the number.
Item number 975, my lord, I want to, my lord, the withdraw because this is wrong determination. The matter has been filed.
Withdraw means?
Withdraw, I seek release, my lord.
Then say release. Which item?
975, my lord.
975.
Yes, 975 of today's list, my lord. Sorry, the monthly list, my lord, 975. I may stand corrected. I'm not.
Please take up then the wrong number.
Of the monthly list, my lord.
What is the name of the party?
My lord, the name of the parties, my lord.
You do not know. Sorry.
May I, my lord?
My lord, I will clarify, my lord.
Sorry, you come with the name, it can be released.
My lord, item number 400 and 401, my lord, contempt matter, my lord. Your lordship give the, my lord, 2023, my lord, return.
What do you want? Upgradation?
Upgrade.
Sorry.
My lord, contempt,
No.
my lord. Your lordship give the opportunity, my lord.
No.
Kindly, my lord, considerable under compelling circumstances, my lord, item 245. What has happened, my lord, behind the back, my lord, section 14's order has been issued by the district magistrate, my DM. Now, my lord, police is regularly harassing me, lord. My husband was died during COVID period.
What
I am
want?
ready to pay, my lord, next week any day because, my lord, police is regularly harassing me, lord.
Thing is, you are ready to pay. Does the law permit you to pay?
That's your lordship will decide.
No. The law has decided. The court is nobody to decide. The law has already decided
My lord, kindly consider,
as to
my lord,
when the money can be paid.
during COVID period, my husband
I
was
do not
died.
know COVID.
And I do not know,
I
my
do
lord,
not
behind
know.
the back, my lord, everything was done.
Yes.
My lord, kindly, your lordships kindly take it any day,
No.
my lord.
Yes.
May I be permitted to mention one matter in respect of item number 516 of today's list. But although, my lord, it's a contempt application, but my lord, it's challenging an order. My lord was pleased to direct the municipality to cover up an open drain. This is not being done. Every day is unbearable. That's why I'm mentioning. Otherwise, I would not have disturbed your lordship with a contempt application.
Who is your other side?
But I have served upon the contemptor, but I can
Contemptor is a municipality.
municipality chairman.
That means a municipality. And who appeared for the municipality in the writ petition?
I at present I cannot name tell you lordship the name, but I know I can inform him.
You can inform him.
Can inform.
Try to bring him today. I'll see what can be done.
So may I be permitted to mention day before yesterday, lordship, I had mentioned this matter. This lordship, there is an order you passed, your lordship, and that order has not been complied with, and that against that order, the against the defendant parties, respondent party has filed an appeal. That appeal has also been dismissed. And my lord, this order has not been complied with. I made an application for contempt application, but the present writ petition is pending before the Honorable Justice Kantha. So against the interim order, I made an application contempt which cannot be listed due to lordship. The writ petition is pending over there.
What you want, you tell me?
the inclusion of the contempt application.
But without the file, it cannot be done, isn't it?
Lordship, because Lordship kindly have looked the interim order, that there is a order of demolition order. That order has been challenged by this party, and the appeal has been dismissed.
The appeal against the interim order is still
Lordship.
dismissed.
Lordship,
Right. It's all right. But then the writ petition is pending before honorable some other court. So the file is over there.
Lordship, but I had mentioned before there.
You go and mention it before the bench that is
I
taking
had
up the matter.
mentioned, but the Justice Kanta is saying that the contempt application can be heard independently. And
It can be heard independently, but in this court, at least the file is required. Yes.
Lordship, what is my
This is a nursing home. But
Hmm.
this is second round litigation before your lawsuits. Item number 270 of the monthly list. I tell lawsuit, your lawsuit passed an order
Hmm.
in relying upon the judgment of the Supreme Court we cited that during the COVID period, NPA could not have been declared. So your lawsuit remanded the matter back to the DMLR for reconsideration. They have not consideration passed the same order. So that's why I'm saying, Lord, police is every day is knocking at the door of the nursing home that they will take the position. Patients are there. So Lord, that's why I'm mentioning if you take up any day convenient to your lawsuits.
Convenient? No. But then if there is urgency, then the litigant is required to be accommodated. Convenience, now the convenience of the court is nowhere. With so many standing in front of me, I cannot say it is convenient. What is the item number?
270 of monthly list.
270 next week Tuesday. Please serve notice.
My lord, may I?
So your lawsuit take up Wednesday.
All right, Wednesday.
My lord, may I be allowed to mention a restoration application, my lord? It is appearing in the list. I've informed the other side. My lord, kindly takes it up.
It is there in the list.
Yes, my lord.
It will be taken up in its usual course.
My lord, kindly takes it up.
Yeah, I will take it up in usual course. Yes, please.
On the 3rd of September, your lordship was pleased to pass the matter with regard to the Puja petition.
Yes, yes.
But now they have opened the gate padlock of the children's park on 6th, but they have again closed it
No,
up.
but then what happened to the appeal?
Well, that has been posted post Puja 6/11/2025.
Yes. So
Nothing has happened.
nothing has happened.
Not a single date has been taken because my lord of prosecutor.
Hmm.
What has happened, my lord? Why am I before your lordship is with a contempt application? Now they have locked the padlock again, locked the children's park. We are not being allowed to enter and put up the construction of the pandal, and they have called us up with in the municipality office. We went there. They said they have verbally informed. Their advocate has informed that until that is disposed of, whatever is the fate of that particular public interest litigation.
Where is the matter? Where is the matter?
And my lord, I am seeking leave to file.
You do not require leave to file a contempt.
No, my lord, I know. I should not, my lord. But why am I coming is because of the fact, my lord, I was just paying for an urgent listing.
Urgent listing, you file it in the department, give the number.
I'm so grateful, my lord.
My lord, kindly leave my lord to mention, my lord, item 478, but it's a hearing matter, my lord. Lord, my lord, I had liberty to mention. I had mentioned earlier, my lord said, try your luck before another bench, my lord. I had mentioned before the other bench, there's a requisition received by this court, my lord, for sending the file.
Release the file
But
immediately.
yes, my lord, that's.
Yes.
My lord, item
478 of today's.
78 of today's list.
Yes, my lord. Lord, a requisition has come, my lord.
478, 1 minute, please.
Shri Orindam
Bhattacharya.
Yes, my lord. Yes, my lord.
Check if the requisition is there, the file is to be released. 478 of today's list.
I'm deeply obliged.
My lord, item number 565, my lord, restoration application, my lord. Urgency is there, section.
No urgency in restorations, I'm sorry.
My lord, it has been.
I am sorry.
Just minute. I think 7th May, the matter was called on when I was appearing before another court, my lord. 8th May, I filed. From that day onwards, it is, my lord, running in the list, my lord.
Yes.
And the rest.
The petitioner's salary was deducted on a certificate case, my lord. My lord, the petitioner cannot continue his livelihood, my lord. Kindly allow this. My lord, I have copy upon.
No, I did not follow. Petitioner's salary is being deducted. By whom? Why?
On a certificate case, my lord.
Certificate case, yes. Then?
My lord, that is why he cannot continue his livelihood, my lord.
So if there are dues to the government, what can be done?
He did not get any single paisa, my lord.
No, sorry.
My lord,
Nothing doing. Sorry.
Kindly, my lord, I'm mentioning upon notice item number 151 of my lord's list, my lord. This is, my lord, challenging a delisting of a company, my lord, without even a show cause notice, my lord, and without opportunity of hearing.
I am not. Firstly, there is a mention in the list that no mentioning will be allowed. And see,
My lord, there's some
Sorry.
urgency, my lord.
No, nothing doing. No, please do not mention.
Contempt application, any day your lordship, not contempt, any day your.
Contempt after the vacation, please come.
My lord. Contempt application, my lord, item 551.
Yes. It must be a contempt application. Who is your other side? Please bring him.
My lord, item number 551.
No, somebody is there in front of you. That is not the system. Yes.
Lordship, I am praying leave to move the matter unlisted, Lordship, at 2 p.m. tomorrow, Lordship, as the urgency is, Lordship, the private response number 6 to 8, Lordship, erecting the bamboo inside the house of the petitioner. The bamboos and to perform the Durga Puja festive 2025, Lordship, inside the house of the petitioner without maintaining the government rules, Lordship. There is a specific rules, Lordship, surrounding to any building, Lordship, 4 feet open space to be there, Lordship. Without maintaining that, Lordship, they have erected the bamboos, Lordship. I have raised objection before the authority also, but the fire department giving the permission to the private resident.
Fire department has given permission. Yes. What is to be done now? It has to be stopped.
Yes, Lordship.
And you cannot manage.
Yes, Lordship.
You cannot manage to move out from this space that is there.
No, Lordship. I have raised objection. I cannot fight against them, Lord.
All right. It will be listed on 3rd of November.
3rd November.
3rd of November. All right. Yes. Yes.
Ma'am, it's a restoration
After
application. It
Puja,
needs to be
Lordship.
included in the list, ma'am.
Lordship, 3rd November, my application will be infectious, Lordship.
Why?
3rd November, how can Lordship? After before that, neither I could not understand, Lordship. 3rd November, the Puja festival will be performed, Lordship. My application will be infectious, Lordship.
Nothing will happen. Next year.
Yes,
Or
Lordship.
next year, the permission will
Lordship,
be
time,
stopped.
hear me, Lordship. If
Once
the
permission has been
application
granted.
married, Lordship, then Lordship, your Lordship, as you, Lordship.
Yes.
Please,
All
and
frivolous applications coming up.
various cases, Lordship, the Honorable High Court also passed order. And
Yes, I am aware of it.
Lordship.
Budvar din deben, Wednesday.
Yes, sir. Restoration application needs to be included in the today's list, or application. It is not included in the list, ma'am.
Last is the date, not
No,
for
not
inclusion.
today, the next Thursday, maybe.
It will be seen. Nothing.
Okay.
Don't hand over the slip.
Your Ladyship, if I may be permitted to mention a matter for inclusion.
No, sorry.
Contempt application.
No.
Lordship,
Yes.
there were
Contempt
238 of
application, your Ladyship.
today's list. 238 of today's list, Lordship, is the contempt application. Order has been complied with. This is
Who are you for?
for the contempt number 1. Lordship.
Yes, and where is the petitioner?
Order upon notice, mentioning upon notice.
You have to bring him.
Contempts have been
It will be there.
contempt of.
If you bring him during the contempt matters, then
The parts of energy is appearing.
item number
238.
238 to bar করে
But I
রাখবেন।
have taken
Some
instruction
notice.
BB Electro, the petitioner. It is to be triggered to a tender matter. It should appear under the group 5. By mistake, it has been filed under the residual.
What is the number?
975 of monthly list. BB
97
Electro.
975 group 5. Check up.
Lordship,
Tender
Lord, Ladyship's kind leave, a contempt petition, my lord, in the original side, my lord. There's some urgency, my lord, we filed it yesterday, my lord. It can be listed, my lord, anytime.
But only for inclusion of a contempt application, why is a senior advocate required to
Tell
come?
you, Ladyship, my lord, the urgency, my lord, may kindly list it tomorrow. My lord, the honorable speaker, by way of instructions placed before your Ladyship, has made false statements, my lord. There was this matter, my lord, which was disposed of by your
Yes.
Ladyship regarding, my lord, prohibiting the security
Yes.
personnel of the MLAs. Now, my lord, there was an intimation which merged into the order passed
Yes.
by your Ladyship. Despite that, my lord, there are instances, my lord, where, my lord, now, my lord, the Honorable Chief Minister is being allowed to enter with her entire cavalcade, my lord. So it is, my lord, on the face of it, my lord, an act of contempt, my lord, made by the Speaker. But what I am humbly beseeching your Ladyship for, why I am here, my lord, mentioning, my lord, may kindly take it up tomorrow, my lord, because
No.
no,
Absolutely no.
limited extent. For the first time, contempt is
No.
coming. No, for preservation of
No.
the CCTV footages also. We have annexed the electronic evidences.
Yes. If
Yes,
you have
it's-
annexed it,
When
the
it's-
number is here, it
Yes.
will appear in the list. Follow the list.
Hey, it an even original set.
Yes.
Grateful to you.
Item number 5.
No, sorry.
Item.
Yes, madam.
Lordship, I have mentioned on 4th of August, inclusion and list. It is not in the list.
What matter is this?
Municipality, contempt application.
Contempt application is not there in the list.
No, my lord. I have mentioned.
Give the number.
Three.
Give the number.
Yes, my lord.
Please check up why is it not there in the list.
My lord, item number 551 of your lordship's list, my lord, is a contempt application. Now, my lord, the writ petition was originally filed by me. My lord, I was a petitioner. The petitioner was dismissed. Your lordship directed to remove the unauthorized construction. And my lord, I subsequently challenged that order before the Honorable Supreme Court. Supreme Court has also directed me to remove the unauthorized construction. We are complying that order. Now, my lord, in the meantime, the Pradhan comes up. Pradhan issues a notice up to me and says that you give up some portions of your own land to the Gram. We will spare you from removing that land, my lord. Pradhan signs an order. Pradhan communicates us that order.
What do you want?
My lord, I want, my lord, because Pradhan is taking because of your lordship, because the contempt application that is pending for your lordship, Pradhan is taking possession of my land also. Pradhan is demolishing my construction also.
Nothing doing.
No, my lord, my land is at
nothing
stake,
doing.
my lord, my lord. My lord, may at least hears me, my lord, 551, my lord.
No.
These are the matters like these are the Chhatra bills matter. Already similar order has been passed by your lord.
No, let it remain.
I'm mentioning upon notice, my lord, this is a contempt application, my lord. Order of demolition has been passed, my lord, unless the authorities' observation is unless the order from your lordship is there is an order from your lordship, the demolition cannot be taken.
Take up in a fresh writ petition. The matter will remain where it is. No.
Lordship, I'm mentioning upon notice item 150 of the daily list for upgradation, Lordship.
No, sorry, no upgradation.
Number 100, Lordship. Is a matter
Upgradation?
Lordship. Lordship, Lordship,
No. Yes.
Subject to the leave of the court. The contender appeared before your lordship.
No, it's all right. All matters there are there. I'm not updating anything.
They will comply the direction of the court and they will demolish the building. But we don't know the reason. The building is remain as it is. Milord, matter is running as item number 499.
The building is there. The court will see what is to be done.
May I have an innocuous prayer?
No, no prayer.
I'm not getting.
No, sorry. Yes.
I'm not getting a certified copy, my lord. Certified copy to prefer an appeal, my lord.
Why?
I'm not getting a certified copy, my lord. There is a title suit which is pending before.
Certified copy of this court's order.
I have filed this writ petition against the district judge of the Barashat court. My lord, I'm not for last 3 months. My lord, kindly, my lord, takes it off, my lord. Otherwise, my lord, my appeal will be coming. I'll not be in a position to prefer the appeal, my lord. Kindly, my lord, your lordship takes it up any day.
Which item is this?
My lord, 1281, my lord.
Combined list.
Combined list, my lord.
Who's the other side?
My lord, I have served the legal remembrancer as well as the Registrar General High Court, my lord.
Check up. Who is your other side? Then come. Yes.
My lord, item 1, my lord, I am the writ petitioner, my lord.
Yes,
an application taken out by me, my lord. My lord, I, my lord, had applied for a credit card, my lord. I was using this credit card of Axis Bank, my lord. Suddenly, my lord, I was informed that my transactions were declined. I found out as to why. It was told that your CIBIL score has gone down drastically low. When I checked up, my lord, I was told that I have taken loans from various entities, my lord, like PayU Finance, Wisdom Finance. These entities have never taken any loan from, my lord. But there were some problems, there's misreporting in my CIBIL account. I called upon them to disclose where did I take loan from, because I've never availed these loans. Well, they did not respond. I filed a writ petition before this honorable court when, my lord, there was an interim order passed by Justice Shausachi Bhattacharya at page 101, where the court directed the authorities to disclose on what basis did you bring the CIBIL score so low. They were supposed to file an affidavit, my lord. An affidavit has now been placed on record, but again, without these documents. The order specifically says, my lord, by Justice Bhattacharya, my lord, that you place on record these documents, basis which, my lord, kindly takes the order at page 99. My lord.
Yes.
Leonard Counsel, may I place the order of 25th April, my lord? Leonard Counsel for the petitioner contends that CIBIL report of the petitioner linked to her CIBIL account with respond number 2 depicts several incorrect statements, entries, and discrepancies as described in para 6 of her writ petition. Since the petitioner has...
The opposition has been filed.
It has been filed. Again, without...
the documents. Let me see the opposition once.
Not filed, sir.
I have been served. I called upon them to provide the basis. Again, they have not provided.
Did you file the opposition?
Served upon me.
Filed it in the department. What are those papers that you are holding?
I'm for the 6 and 7.
6 and 7.
That's bank, my lord. These banks, my lord, I have never availed any loan from. So I wanted them to
Have
show
you
documents.
circulated
All document, my lord, whatever is in the opposition, my lord.
the loan and everything?
Yes.
6 and 7 did you get?
No, my lord.
My lord, 6. My lord,
Respondent
as
number
per the
2, my lord.
feedback.
6 is not concerned. 2 is Axis Bank, my lord, where 2 is Sybil. I stand correct. 2 is Sybil, my
I've
lord.
got the Citibank and the HDFC Bank.
So basis which Sybil has drawn my scores low, my lord. I wanted Sybil to show the document.
Please wait. You are for?
HDFC Bank and Citibank.
And your contention is that the petitioner took loan from you.
Yes, my lord. They
And
use
you
the
say that
credit
you
card.
did not
No,
take
my lord.
loan.
No,
The credit card, my lord, Citibank, their HDFC card still they are there.
my lord,
Using
kindly
the HDFC
seize the affidavit, my lord. It's terms and conditions. No documents to show that I have applied for or availed any loan. So they are saying we have documents. We say place the documents. Kindly see what
Documents are annexed possibly.
no documents are. Kindly have a look, my lord.
Citibank documents.
Kindly have a look, my lord.
Documents as for
Page 16 onwards.
guidelines, my lord. We have all disposed of all documents, my lord. Since the requirement is the 10 years, I have to maintain. According to RBI guidelines, I have disposed of that.
So the loan is for more than 10 years.
More than 10 years, my lord.
Give me the date when the loan was taken.
My lord, give me one second. This is a credit card. This is not the loan, my lord.
All right, credit card.
Yes.
Yes. When was the credit card applied for and given to him?
Any document, my lord.
In the interim, IA, what have you sought for?
I asked for these documents, my lord.
For that, my lord, this petition is maintainable, my lord.
Not ready?
Can you give me 1 day time, my lord?
Please check up where your opposition is because your opposition is not on record. You file it in the department? All right, please come back. An interlocutory application has been filed by the petitioner seeking documents relied upon by the respondent number 2 in its affidavit in opposition. Stop. The affidavit in opposition of the respondent number 2 is not readily available on record. Stop. Learned advocate representing the respondent number, you are
6 and 7.
6 and 7 seeks time to come prepared. Release next Thursday, 18th. Stop. The department is directed to transmit the affidavit in opposition of the respondent number 2 if the same has already been filed in the department. Stop. Learned advocate representing the respondent number 6 and 7 shall come ready with proper instruction. What about Axis Bank?
Axis Bank, my lord, is the real bank, my lord, who has said that.
Yes, can give notice.
I shall inform.
Respondent numbers 3, 4, and 5 are not
I will
represented.
notify them.
5. HDFC?
I am for the HDFC, man. Citibank and HDFC.
All right.
6 and 7.
3, 4, 5 are not represented. Let notice be served.
My lord, may I file the affidavit of service?
Affidavit of service filed in court is taken on record.
Deeply obliged.
My lord, I have filed an affidavit opposition, my lord.
Yes, affidavit in opposition of the respondent numbers 5, 6 and 7 filed in court is taken on record.
Thank you.
Time for the respondent. Your Lordship, I'm for the petitioner, Lordship. On the last occasion, Your Lordship, we had taken time for taking instructions from the client, Your Lordship, with regard to page 79 of my writ petition.
Yes, 79.
Yes, Your Lordship. Lordship, upon instruction. Your Lordship.
But insofar as page 79 is concerned, but we have taken instruction.
Yes.
This was received, this was issued because of the fact that we were delisted temporarily. And till such time, we would do the quality audit test. We would not have been permitted to supply these materials ever again. So this letter was issued. I can't shy away from this letter. The principal grievance now is they have rejected certain materials. They have asked us to replace them. But what they can do, or rather they should do, is return the materials back to me so that I can replace them and send them. And my lord,
So right now your prayer is for returning the materials to you.
and my lord, yes, my lord, that is, I'm restricting my prayer to that. And my lord, lordship will kindly take page 90 of my writ petition. Here, my lord, the railways, they are saying that after examination, the samples have been found to be of substandard quality as per some ISO
Yes.
document. Then, my lord,
That is not the prayer in the writ petition.
no, my lord, kindly see the second paragraph. The subject locked FF3 such and such contains such and such.
Second paragraph of what?
Second paragraph of page 90. 90. I'm so sorry, my lord.
No, it's all right. Yes. Yes.
I'm being led by Mr. Ban.
Yes, yes, no issues. Page 90?
That should kindly grant me leave, my lord.
Yes.
Page 90, the lordship will just have a look at once.
Hmm.
You know, this rejection that has happened, one of the subject lot FF3 by 9. You know, the issue was with regard to inspection in my presence. So the respondent came and said that by a preceding letter, previous letter, we have accepted that the goods are faulty
Substandard
or
value.
substandard, and therefore we can't take them. I don't want to address your lordship on that immediately. Page 90, your lordship will just have a look at once. The subject lot of this, containing these number of elastic rail clips, has been issued to different consignees from so and so. Is advised to identify the above lot and demand user OL consignees to return the supplied defective lot supplied, if any, for replacement. Kindly have a look at the bottom, my lord. The petitioner is for replacement of material. So two things, my lord. One is my goods are faulty. I have to replace it, and it's my obligation to replace, but they will identify these goods and then they will collect these goods from a different consignee that has gone to. Your lordship will direct them to identify these goods and send me these goods, and I will replace them.
That is not your prayer in the writ petition.
Prayer, I'm not asking for a lesser relief. In my everything I'd ask for setting aside of
Yes.
whatever.
3 months time was given to them for replacement. After receiving this letter, they had not issued any letter.
So what have you done with the goods?
My lord, for that I have to take instruction. They have to replace within 3 months from the
I
date of-
follow it. But suppose they do not replace, replacement is next step, is the next step.
we can issue-
But then first step is returning the goods for replacement.
For replacement. My lord, kindly come to the clause first.
Which clause?
Clause.
No, is it the case that you are not supposed to return?
Supposed to return after 3 months.
You are not supposed to return. All right.
They have
Show
to pay
me.
the penalty.
Yes.
My lord, kindly come to the purchase order.
এটা কোথায় পেলেন? রোজ নতুন নতুন জিনিস এসে পড়েন আপনারা। Impossible ব্যাপার।
My lord, the purchase order starts from page 41. My lord, kindly come to page 44. The guarantee. Clause number 11, guarantee.
Yes.
The contractor guarantees that the stores which the supplies shall be manufactured fully in accordance with specification. In all cases, the contractor guarantee that its design shall strictly follow the as made detailed drawing with such modification as are notified in respect of each type. B. The contractor further guarantees that the store shall be free from defects in materials and workmanship. The contractor shall be liable to arrange the necessary replacement of the defective stores free of any charge only to the extent that such replacement are attributable to or arise from faulty workmanship of materials or design in the manufacture of the stores. All replacement shall be made free of cost of destination. If the contractor so desire, the replaced stores can be taken over by him for disposal as he deems fit within a period of 3 months from the date of receipt of the replacement to defective stores by the purchaser. But the expiry of this period,
Yes.
no claim in this respect shall
Correct.
lie on the purchaser.
No claim can lie. So, my lord, my primary obligation is to replace only if this is made over to me.
After that,
Kindly see the
after
next
3
clause,
months, I
madam.
have no obligation.
1 minute. Next clause,
Acha.
yes.
My lord, next is the guarantee herein contained shall not apply to any material which shall have been reported or altered by the purchaser or
This is
or
not
this is
applicable.
not important. My lord,
The
next one. The
guarantee
guarantee herein shall expire in respect of each item of a store on the expiry of 30 months from the date of its delivery or 24 months from the date of its placing in the service, whichever is earlier. In this case, my lord, it is done within the period within 30 months from the date of delivery. All replacement, my lord, all replacement that the purchaser shall call upon the contractor to deliver under this guarantee shall be delivered by the contractor within 3 months from the date on which the purchaser call upon him for the replacement of the defective stores. If the contractor fails to replace the defective stores within the said period, the cost of the said stores at the rate stipulated in the contract shall be recovered from the payment due to the contractor, including the amount of the security deposit made and maintained under clause 2 of general condition of contract.
Yes.
As they have
E is actually what I am addressing your lordship on. No?
Why not E?
No, E is my obligation to replace upon B happening.
But all these things are contractual issues. Please come.
No, they'll just.
No, sorry, nothing doing.
I'll just indicate.
The
No, they'll have to return the goods, which they found defective. Then I'll replace.
Yes.
No, that is B is very clear on that. At page 44.
The petitioner
And my
refers
delisting
to
order is under challenge. My lordship will not
page
dispose of the writ petition.
90 of the writ petition. And seeks for a direction upon the railways to return the defective goods.
Lord, may I just pray for one?
So that
Your lordship
the
will forgive my
petitioner can
rejection, Lord.
replace the same.
No, my lord, my delisting today at this stage I was praying for that. My delisting order is under challenge. If your lordship is not giving me an interim order, it's all right, but let them file an affidavit because my delisting order will address your lordship. Because the delisting has been issued on the basis of reliance on an ISO document which doesn't apply to my tender. Kindly keep the writ pending, my lord. My challenge will be there. Otherwise, I send delisted from the railways.
The primary relief sought for by the petitioner is quashing the temporary delisting order dated 27th November 2024 and the warranty rejection advice dated 27th June 2025. Stop. It appears that the petitioner stood delisted because of the substandard quality of the goods delivered by it. Stop. From the documents annexed to the writ petition, it appears that the petitioner accepted that the materials delivered to the railways were of substandard quality. Stop. Paragraph. As an interim measure, the petitioner prays for returning the defective materials so that the petitioner can replace the same with proper materials. Stop. Learned advocate representing the railways relies upon the terms and conditions of the purchase order, wherefrom it appears that a specific time period is mentioned within which the supplier is required to take back the goods in case the same is found to be defective. Stop. The time period within which the goods were to be taken back has expired. Stop. The purchase order requires certain payment to be made by the supplier. If the supplier intends to take back the goods after the expiry of the stipulated period. Stop. Upon hearing the parties, it appears that the entire dispute arises out of a contract in between the parties. That's a commercial contract. Stop. The parties are bound by the terms and conditions of the contract. Stop. It will not be proper for the writ court to enter into and adjudicate such issues. Stop. Next. In view of the above, The court is not inclined to exercise jurisdiction in the matter. The writ petition fails and is hereby dismissed. Stop. Dismissal of the writ petition will not stand in the way of the petitioner from approaching the competent forum
Great.
for adjudication of dispute in accordance with law if so advised.
Great.
I appear for the respondent bank.
Yes.
This is one of those writ petitions, my lord, where my lord showed your lordship the glaring fraud on the part of the bank. My lord, why I say so, my lord, unfortunately, my lord, the Death Tribunal is not vested with the power of contempt. In spite of there being an order of stay, my lord, the bank has proceeded to issue a sale certificate. And I'll show to your lordship from the very inception, my lord, the bank has committed fraud because, my lord, your lordship knows.
Please show.
Yes, my lord, now first kindly comes to page 136.
Yes.
So that's the order of stay, my lord. Kindly comes to the last 3 paragraphs. The details of the auction purchase and details of the sale have been filed by the respondent bank with a copy of essay applicant. Essay applicant is directed to appear before the learned register on such and such for implement of auction purchaser as a part to the essay proceedings. Register is directed to facilitate this amendment. The purported sale, my lord kindly takes note, the purported sale which has taken place on 12th of February 2025 shall be subject to the outcome of the IA challenging the sale, that is IA number 62125. Now, my lord kindly considers the date, that is on 6th of March 2025. So this is the order of stay which has been passed.
Stay? Where is the order of stay?
My lord, subject to the outcome of IA, so my lord, they cannot, my lord, proceed with the sale certificate. My lord, it is implied.
No, sir. I beg to differ and I'm not accepting.
Kindly considers, my lord.
I have considered the one line that you showed and the explanation.
If the sale certificate is issued.
Yes. What happened to the IA?
The IA is still pending.
Yes. So whatever is the result
where
of
would
the
I
IA?
go, my lord? Where would my right go, my lord? Without
go before the tribunal.
Lord, I have
Stop. No,
Lord,
no.
now another glaring discrepancy, my lord, I'll show to your lordship.
Yes.
Lord, is the very inception. My lord, kindly comes to page, my lord, the EMD. My lord, once a reserve price is fixed, EMD is also fixed. So, my lord, any bidder who bids cannot bid less than the EMD, and the bank cannot proceed on that. Now, my lord, kindly sees page, best of all. Lord, kindly first takes up the sale notice once. Page 185. That's at volume 2. Now, there are 2 properties.
Yes.
Kindly takes note of the earnest money deposit, that is 2.92 lakh, and my lord, at the last, my lord, 2.70 lakhs. So, my lord, that is the determined EMD by the bank. Now kindly comes, my lord, apropos this to the page 224, that is the memo of consideration.
Why will the court look into your interim application?
My lord, may kindly cease their prayer. Their prayer, first prayer is, my lord, to set aside the order of the district passed by the district magistrate, your lordship. That has been decided by the DRT, my lord. It will appear, my lord, from page.
Lord, may I complete my part? Then my learned friend will start, my lord.
My lord, may kindly takes up page number 154.
Yes. What else do you have to say?
Kindly comes, my lord, to page 224 first. I have indicated the amount 2.92.
Yes.
Well, kindly sees the shortfall 2,91,300. Similarly, my lord, at page 194.
The petitioner is aggrieved by the steps taken by the Punjab National Bank
And
to
my lord,
recover
kindly
the
look
loan
in the
amount.
bearing issue of the possession being handed over on the same date when, my lord, the sale was confirmed. Cannot be, my lord. On the same date, it was completely. My lord, kindly have a look at page 219 once.
Petitioner is aggrieved by the steps
My lord, the subject is before the DRT.
National Bank to recover the
Loan amount relying on the provisions of the SARFAESI Act. Stop. It appears that the securitization application filed by the petitioner and the interim application filed by the petitioner in connection with the securitization application both are pending disposal before the Debts Recovery Tribunal. Stop. The tribunal, with a order dated 6th March 2025, directed that the sale which took place in February 2025 shall be subject to the outcome of the interim application challenging the sale. Stuff. Paragraph learned advocate for the petitioner interprets the same as an order of stay passed by the learned tribunal. Stuff. The court is not inclined to accept such interpretation. Stuff. As the securitization application and the interim application both are pending before the tribunal, it will be open for the petitioner to raise all issues before the
May I make only
forum.
one innocuous prayer, my lord?
The
Since, my lord, time is of essence, my lord, lordship will
the
direct, my lord, for
petition is not being
expeditious
entertained.
disposal, my
My
lord.
lord,
Stands
the
dismissed.
interim application challenging the section 14 application has been disposed of, your lordship.
My lord, only one innocuous prayer, if your lordship, my lord.
The
wants it.
interim application
That's
challenging
section 14. I'm not in
14
the.
order that
I'm not in
whatever
the
is
stage
there,
of section.
it is there on record.
Only
it's
one
on record.
indulgence, my lord, one kind indulgence, my lord. Let it be
Grateful.
disposed of within a time frame. Because, my lord, your lordship knows these applications, my lord, kept pending my property rights, my lord, to be adjudicated. If it is done in a time bound manner, your lordship knows, my lord. No, the eye to the sale notice.
The tribunal is requested to consider and dispose of the matter at the earliest without granting any unnecessary adjournment to either of the parties.
deeply obliged, your lordship. Much obliged.
My lord, in that series of writ petition, my lord, I am just left to answer with one writ, my lord. Lordship will be pleased to take up. My lord, the main writ petition, Manoj Toshniwal, I had completed my submission. I had also made my submissions for the corporate guarantor, that was MKN. And my lord, I have also made my submission on Biplab Bose.
Yes.
One of them had expired, so Lordship has recorded that that has become infructuous because it's
Not yet recorded, but then his
yes,
death has been recorded.
because
Now it
it's
will
action
become.
in personam, so it will not. So, my lord, I am only left with, my lord, this is Sunita
Sunita
Bardia.
Bardia.
This is WPO 4448.
Yes.
My lord, here, my lord, the main submission was based on a recording in the minutes of the meeting, which starts at, my lord, page 117, volume 2 of the writ petition. That the contention is that the guarantee was discharged and thereafter I cannot be liable for the default. 117, it starts, my lord, the relevant portion is at 119, para 12 was relied upon.
Yes.
That first sentence, second sentence, well, third sentence, which will be the fifth line of paragraph 12, Mr.
Yes.
Behera clarified, Lordship has found that?
Yes, yes.
Mr. Behera clarified that as per the third supplemental working capital consortium agreement executed on 29 September, the said property stands automatically released from mortgage and also the personal guarantee of Mrs. Sunita Bardia and corporate guarantee of Locason mortgage also stands released by the consortium lenders. Well, this is what the petitioner relied upon. So, my lord, Sunita Bardia, the guarantee was released, and my lord, this document is 16th of June 2017. Now, my lord, kindly takes, and my lord, the primary contention is that you have invoked the guarantee in 2018. Since it was released, you cannot have any cause of action. My lord, kindly take the affidavit in opposition of IDBI Bank. After this, my lord, sanction was granted on 18th October 2017 for 200 crores, which Lordship will find at page 19 of the affidavit in opposition.
This paragraph number 12, is there any date?
Well, this is part of the minutes of my lord, page 117. If lot
All right. Part of the minute.
part of the minutes, my lord, para 1 starts there, and para 12 is a continuation. It continues till up to 120.
Right. This is 16th of June 2017.
16th of June, yes. 16th of June 2017. I mean, in October 2017,
yes,
200 crores credit facilities, fresh credit facilities is submitted, sanctioned. And my lord, in this sanction, my lord, 18th October 2017, this is on 18th October, my lord, when it was found over here, my lord, initially page 23, lordship will find the personal guarantees were of Sundarlal Dugar, Manoj Toshniwal and Ramesh Chand Bhatia, which is, I believe, my lord, a relative, either husband of somebody of Sunita Bhatia, Ramesh Chand. Then, my lord, 2 days thereafter, and this is an admitted position also, because I'll show from their reply, it's not in dispute. There was an addendum to this because it was noted that Sunita Bardia had been left out. So 2 days thereafter, on 20th October 2017, which is, my lord, at page 29.
yes,
That addendum to sanction letter of 20th October. Please refer to a sanction letter of 18th for working capital of 200 crore. The additional terms to the above sanctioned are mentioned herein. In case the terms and conditions are acceptable, you may return the duplicate copy of the letter signed by you, so and so. Well, first term is personal guarantee of Sunita Bardia to be furnished in addition to existing guarantees mentioned under point number 1 of the above mentioned sanction letter. The Usance committee will minor increase in charges because there was some variation, so the charges also increase. And then when it kindly turns over.
The submission was that the personal guarantee of Sunita Badia was never furnished.
No, I'll show that.
All right.
Point was it was discharged. Initially furnished, revised sanction, subsequently discharged. There's a approval meeting by the joint.
All right, I'll come. Please wait. Yes.
At page 30. All other terms and conditions of the sanction letter remains unchanged. Letter forms an integral part of the sanction.
Yes.
And the first paragraph, Lordship has noted the second sentence at page 29. In case the terms and conditions are acceptable, you may return the duplicate duly signed by you, your authorized person, along with this accepted sanction letter. Then, my lord, page 30 and then 31, kindly see, my lord. Yes. Personal guarantor Sunita Bardia confirms. And my lord, kindly see the affidavit in reply. And they admit this document. It is not denied. My lord, page 5 of the affidavit in reply. But the contention is the additional sanction was there, but thereafter I did not execute any fresh document. But my lord, this is sufficient in my respectful submission so far as to confer liability. Page 5, my lord, subparagraph G. When this is pointed out,
yes,
in the opposition, this is the stand in the reply. There is no denial to that. Significantly, the issue of discharge of my personal guarantee in the consortium meeting held on 16 June is undisputed. It was also specifically pointed out in the sanction letter of October 2017 and the addendum to the letter specifically recorded. So they are referring to that addendum. Addendum to the letter specifically recorded that I was required to furnish a guarantee. The fact that I did not furnish a guarantee has been unequivocally admitted by the respondent. Well, when you confirm that and you sign as the personal guarantee, I don't require any other document. Because, my lord, the addendum specifically says that this is the addendum. If you are agreeable to this, get this signed and returned. And when we point that out, my lord, all the personal guarantors in the initial letter, only the one of them had signed. Sunita also signs and confirms it, and thereafter, my lord, the funds were released. So, my lord, I don't require. Document is admitted. And, my lord, the only defense is that they are thinking another document is required. But, my lord, this in my respectful submission is, my lord, confirmation of guarantee by Sunita Bhatia. Look, that takes care of all the 5. Those are
all right. Yes, reply.
My lord, there are total 5 matters.
Yes.
My lord, 6 matters.
One has expired, possibly.
Yes. One has expired.
Yes.
So that leaves behind 5. The one that has expired, my lord, this is a action against the person in personam. So that it is. So, my lord, Mr. Mukherjee is leading us in one. That is the first one, my lord, Manoj Toshniwal.
All right.
If your lordship sees item 5.
Yes.
So then I have addressed your lordship in the other two. So, my lord, if Mr. Mukherjee starts his reply, so my lord, we don't have to repeat, because the reply has to be consolidated one, because I cannot reply in a piecemeal manner.
So today no reply.
I don't think, my lord, in any event, my lord, it is 11:30. So we will take some time in giving the reply. So, my lord, kindly give us one date when we can come back and reply.
18th চেয়েছিল বোধহয় তোমার আগের দিন 18th বলেছিল
After 18th
18th
was
or
the
something, 18th
request.
something.
But then last week prior to the vacation,
I can understand.
reply you can
Yes,
answer.
yes, yes.
I can understand.
And then it spills over. I don't know what's going to happen.
Lordship can treat it.
There is a note, Chief Justice's note, that it cannot be treated as heard in part after the change of determination.
Yes, where part had marking now is creating lot of controversy.
So, and for me, this bench, not a single part had matter. Never.
18th এ করে
So
দাও।
I would have liked it if your lordship makes it makes this an
And
exception.
the
করো আমার কোনো আপত্তি নেই। সংবিধান হয়ে গেছে তুমি কি আটকে থাকতে হবে?
respondents conclude arguments. Stop. The petitioners intend to give a reply after the 18th of September. Stop. Released on 25th September.
25th.
18th is a Thursday. After 18th, 19th, Friday, it's not possible. So it's a last week.
So last week, your lordship, that's what I was considering.
So it will go after the vacation.
After the vacation.
Nothing doing.
If 18th is permissible, I think Mr. Mukherjee is available on 18th.
Yes, yes.
18th
After 18th was the submission.
No, my lord.
No,
not
18th is
18th
good.
is available.
আচ্ছা তাহলে 18th এ fix
18th is available.
So it will be
18th released on 18th মানে ওটা তাহলে কেটে দিন, just released on 18th করে দিন।
18th.
আচ্ছা আর একটা লিখে নিন তো 6/7/2024 the writ petition has expired. Writ petitioner, stop. As the steps taken by the bank are in person.
Your Lordships, I'm sorry to intervene, Your Lordships. I just checked with Mr. Mukherjee. Lordships, if I may. Your Lordship,
Yes.
Mr. Mukherjee is requesting for 22nd, Your Lordship. 18th.
Very well. I remember it was after 18th. Now it's said after 22nd.
very.
Yes,
Yes,
so it
sorry,
goes,
man, I caused
so
the
it goes over
I caused the
to the other side of the vacation.
Well, unless, my lord, your lordship can keep it on the 22nd, subject to your lordship's convenience. My lord, may I just say this, my lord? Let it remain in the let it remain on 22nd. In the event your lordship
After 22nd is the submission. That means 23rd.
No. Your Lordship, on the 22nd.
on
On
the
the
22nd.
22nd. That's the 22nd day রাখুন. Let us
And
see
in the
what
event
can
your
be
lordship
done.
will see if
Let
there is
in case, otherwise I want
the
to finish
urgent
it up.
matters, very well. If motions are there, your lordship can
Yes.
thereafter
কি বললেন?
taking it over after the vacation.
Personam, the death of the petitioner puts an end to the entire issue. Stop. The writ petition accordingly becomes infructuous.
Good. 22nd.
চেম্বারে আসবেন।
Your Lordship, I'm for the petitioner. Yes, I had
For the respondent.
mentioned this matter, Your Lordship, of non-prosecution. I have written instructions from the client. The client does not wish to proceed this matter. I have served on my learned friend as well.
Non-prosecution. Yes. You are there for the state?
No, Lordship, I am for the respondent number 4 and 5, Lordship.
Give your appearance. Did you file your wakalatnama?
Yes, Lordship, not yet, but
Yes, not yet.
not
What?
yet. We have instructed to appear, Lordship, but we have not filed the wakalatnama, Lordship.
Will you file it?
Yes, Lordship, we will file it today.
Give your enrollment number.
Okay.
Record the enrollment number. If the wakalatnama doesn't come, then it will be a problem. Yes, call the next one.
Lord, I am for the petitioner, my lord. We mentioned
Yes.
extension, my lord.
Yes.
It is that matter in which, my lord, we have challenged the order of the appellate authority under the Apartment Ownership Act, by which, my lord, the appellate authority has permitted, my lord, an adjoining land which is not part of the original
Alright.
project to be amalgamated,
Hmm.
and not to be amalgamated, but to be, my lord, included in the Apartment Owners Association. We have
Hmm.
challenged that. We say that it is a separate land, not part of the project, cannot be done. Your lordship, report was called for, my lord, report was filed, an interim order was passed by your lordship on, my lord, 7th of May. Which is not till, my lord, 26th of September.
Hmm.
Only one difficulty has arisen, my lord. We have prepared a supplementary affidavit. The developer has given a notice that they are going to, my lord, leave the maintenance of the society since the owners are not forming an association. These are supplementary affidavit, my lord. Now, if, my lord, before the puja they vacate, the matter is pending. Your lordship has directed that association shall not be formed for the time being.
Hmm.
Now, if the developer, my lord, leaves,
Hmm.
the entire, my lord, maintenance shall come to, my lord, before the
Stand still.
standstill. Mr. Banerjee is here, my lord. I'm handing over a copy. If he
But I
takes
was not
instruction, my
aware.
lord,
Yes, I was not aware
he
of
was
this
not aware.
notice, but my lord, so far as the merit of the writ petition is concerned, my lord, there is something, my lord, to say.
Yes, something to be said at the time of hearing.
let them not leave the society at this stage, my lord. They
That
cannot.
is, my lord, law, my lord, does not permit us to maintain. My lord, after
Uh,
a certain period of time, there is
yes.
penal provision, my lord, which
Right.
says if my lord, an apartment owners association is not formed within, my lord, a particular time from the date of,
But
my lord,
why is the association not being formed?
Not being formed because they started the
for
process.
me, my lord, was
Now the garages, my lord, of
Yes.
the various flats, my lord, they have, my lord, given the garage to some in some other land, other plot of land, which is not part of the sanction plan or the completion plan. We objected, my lord. They have not executed a gift deed in our favor, which was never accepted by us. We have challenged that also. We have annexed that the registering authority
But the
subsequently.
gift deed will be challenged before the
Yes,
civil forum.
that is, my lord, that has
Not
been
here.
done. Authority has said that no, it was incorrectly done. That also we have annexed.
All
That
right.
registration cannot be done in the absence of the donees.
Hmm.
That is a separate chapter.
Hmm.
But so far as not amalgamation is not done, if amalgamation is not done and the land is not brought within the purview of the project, legally, my lord, it cannot be made part of the association. This is our contention. We'll submit on that.
Hmm.
Now, under the, my lord, RERA Act also, my lord, it's a duty of the developer to form the association and go.
correct.
It is one of the responsibilities.
Yes.
Just like he says that there's a time limit is given.
Yes.
Now, at this stage, if they will not leave without formation, kindly
Mhm.
see your lordship's order is that for the time being, formation. be
Show
stayed.
me the time period which is
Yes.
mentioned for the developer to hold.
Kindly take, my lord, the West Bengal Apartment Ownership Act once.
Yes. Hey, Kailash, West Bengal Apartment Ownership Act. How many members are there?
Total কত আছে? Number of flats জিজ্ঞেস করো। Total flats কত? I'll appraise it. Total 524 apartments, my lord.
524. That means a huge property.
Huge property. Huge property.
And maintenance is required. It is not 5, 10, or 20.
No, my lord, it's not that. Now
So
the matter is
maintenance is very much
required. Not at this stage, my lord, Mr. Banerjee, let him not use his good office. Not for the time being, at least not till
No, for-
kindly fixes after vacation. Let
Where
him
is,
not.
where is that provision? Where is that provision?
Yes, my lord, that is, my lord, in the bylaws of the, my lord, West Bengal Apartment.
Bylaws.
They have to lawfully form. If they don't form it lawfully,
Then,
done,
my lord, I
court injuncts, then this
kindly,
provision
my
will
lord,
not come into
indicate
play.
that. Kindly indicate that.
But kindly
Because,
indicate
my lord, law says I cannot do this.
But
And if I do
there is
this,
an interference
my lord,
of the
may I? My lord, law says I cannot do this, and if I do this, my lord, I shall be sent to prison. That is what the law says.
Section.
If my lord, then my lord permits me, my lord, to do, my lord, to collect money from them, and they are happy, my lord, to make over money to me as maintenance charges, my lord will go by what my lord says. Definitely.
Are you getting the maintenance charges?
My lord, they have to, my lord, pay that.
No, are you getting it?
As of now, no. I
No.
cannot maintain.
Since when?
কবে that milord I need to কবে কত দিন
Then how
The
who
last
is
3
paying?
months, majority of the flat owners are not
members
paying.
are paying, but in every house, every milord apart.
My instruction is
There
that,
are,
sir.
yes, some, that is different. But then the money that you are receiving, is it enough for
No,
maintaining the
not
property?
at all.
Here I am joining an issue, my lord. I have taken a specific instruction to that. Majority of the flat owners is agreeable that even if someone is not cooperating, let them take steps against them.
I cannot. Law does not permit me.
The association has to take steps. Why you will
Because, my lord, the problem
trouble the developer? He has developed the property and he'll move out. And giving everything to the association.
He is not ready. Only one point where
He is not ready.
He is not ready, my lord, to amalgamate the, my lord, portion wherein apart from project area they have given the flat owners the, my lord, car parking
My
space.
lord, on
There
this
is a
plea,
specific
they are not
above-
paying maintenance charges on
Yes,
this
yes.
plea.
No, I-
Law does
we
not
can- we
require
can-
me
we
milord
can
to
say this, my lord.
amalgamate.
If
They
it
have
is
their
the
own
part of the
property.
project,
They
there's
are
no difficulty.
parking cards.
We have annexed the completion plan and the original sanction plan. Both milord does not include that land where the garages have been allotted. If they can make it within that plan, milord, then we can get everything done.
What is the way out? How can
Way
it
out
be
is
brought
only,
into?
milord, formation of an association.
No, no, that is only for the management and
True,
supervision.
true.
What about the amalgamation part?
Amalgamation is not required under that. Kindly take
No,
that.
it cannot be.
That's the part of the project.
Otherwise, the apartment owners also have an undivided share to that portion of that
Kindly, milord,
property.
take the law. Kindly take the law. Milord, the law is completely otherwise.
No,
Milord,
sorry.
with conviction, milord, kindly have a law defines property.
Very well, that
Milord,
has to be decided.
yes, milord, kindly
But
decide.
then,
Milord, they will give a land in Hooghly
and
and say that this is
project
part of
area
the
will be
project.
at
Milord,
Howrah.
these are all in the air. These are all in the air. Milord, they are assuming something which is not the facts of the case. These are all adjoining lands. Property definition is there under the statute, milord.
Provision of
Milord,
law.
I am ready
where
with the
amalgamation is
provisions.
there.
supplementary affidavit filed by the writ petitioner is taken on record. Stop.
Milord, kindly allow us to use, milord, and response to this, milord, supplementary. I do not know what is there, milord, in the supplementary. Kindly allow me, milord, to use an affidavit in response to this.
What is there?
First, milord, that notice given by the milord developer that they're going to leave, that is last two annexures, and before that, milord, we have annexed, milord, the notice from the ADSR, which says that the give deed was not regularly done because the donees were not present. Their fingerprints have not been
That is
taken.
not the subject matter of this writ
Oh, no,
petition.
but
Can't be the subject.
it is relevant for the purpose that
The,
gift cannot be said to be a valid deed.
File court is taken on record. The supplementary affidavit annexes the notice issued by the developer on 24th July 25 and 30th August 2025, disclosing that the developer will not be handling and or overseeing any maintenance work of the project from 1st October 2025, irrespective of the fact whether any committee / association / group of flat owners takes over the maintenance activities or not. Stop. It has been brought to the notice of the court that there are nearly 524 flat owners. Stop. The association, however, of the flat owners has not been formed till date. Stop. Are you all taking steps to form the association?
Step was taken by the developer. An order was passed, which we challenged before the authority that it cannot be done unless that amalgamation is done. The competent authority held in our favor said that no, this cannot be made a part. That was challenged by the developer before the appellate authority. Appellate authority said no need of amalgamation, you make everything part of the
I have a suggestion,
that is
milord, if it commences to your lordship. Milord, maintenance is at stake. Milord, they will suffer, I shall also suffer. My lord will kindly form an ad hoc committee, milord, from them. I, milord, don't need to be there.
How can the court
leave like this?
How can the court form an ad hoc
Milord, this
committee?
property will suffer from, milord, lack of maintenance.
Yes.
Milord, I cannot maintain.
They are leaving without
Law
formation will
prohibits
also be a violation of the
Law
act.
prohibits me from not getting the money.
The
Law prohibits you from
petition
leaving without
is,
formation.
That's
required
not the
to
law
be
but
heard.
with the deepest of respect.
Stuff. As the issue is pending consideration before the court, accordingly, the developer is directed to continue maintaining the property subject to the charges being paid by the flat owners.
Your interest is protected.
Stuff. The interim order that is subsisting is extended till 19th December 2025 or until further order, whichever is earlier.
And kindly, my lord, also allow me then, my lord, to take steps if, my lord, maintenance charges are not paid.
What steps will you take?
My lord, I can then stop, my lord, maintaining, my lord, those flats. My lord, taking, my lord, sewerage, garbage. Who will
Only
be the
those
default?
flats.
Who will be default?
All right, liberty to mention. You come, then
My lord,
something
kindly
else
and
will
one
happen.
line. Otherwise, my lord, there will be again a chaos.
Would your lordship,
Please
my lord,
come,
kindly,
does not pay.
mention.
kindly fix the matter after
Mention.
application, my lord. This point can be taken care of once and for all.
We will argue, my lord, not more than.
No, it will not take
but I
much time.
assure
Only the provisions?
because everything boils
A
down
list
to
for
the
hearing in
amalgamation.
the combined monthly list of November.
November.
Grateful,
Grateful,
Grateful to your
grateful.
lordship. Oh. Grateful to your lordship.
Lordship, in item number 3, Mr. Shantanu Kumar Mitra is appearing for the state respondent, Lordship. Lordship, due to some eye problem, he could not come to court today. Few days back, he had gone through a operation, Lordship. He is feeling some eye discomfort, Lordship. He couldn't come to court today, Lordship.
Are you there?
No, Lordship, I am not in this.
Who
matter,
is assisting Mr. Mitra?
Kakoli Noshkar.
Call him. Call her.
Lordship, no accreditation notice served upon the respondent number 226. Lordship, Mr. Samuel Kumar Das appearing. I am praying for only 1 day accommodation, Lordship.
You didn't serve notice of upgradation?
My lord, the matter was about to appear on 10th. My lord, it was the 10th notice was served upon them, my lord. And my lord, I
26 under the
yes.
And my lord, on 10th, I mentioned before your lordship, my lord, the matter is appearing today, my lord. Matter
Yes.
was
So how will the other side get to know that you are upgrading it?
It was item number 126 yesterday.
Tomorrow I'll take it up.
No, my lord, there is an apparent urgency, my lord.
No,
only
lordship.
one thing, my lord.
Tomorrow also it cannot wait.
My lord may only see for 1 second, my lord, only.
Without hearing the respondents.
My lord may only pass an interim order. Why I will tell your lordship once, my lord.
Yes.
Once, my lord. My lord once takes up my writ petition, my lord, for once, my lord.
Let me see.
Lordship, earlier.
My lord may kindly come to page number 22. I will not argue more than 2 minutes, my lord. My lord may kindly takes page number 22 for once. For once, my lord.
They are the private respondents. Who are you?
Private respondents, they are the developers, my lord.
Developer.
Developers, my lord. My lord, their project, 34 Kathas project, not registered with the RERA. Not so, my lord. I have approached before the RERA, saying that their project has not been registered. RERA has acknowledged their non-registration. Page number 22 is that order, my lord.
Yes.
Now, my lord, kindly comes to the operative portion. Page number 26, last paragraph.
Yes.
The respondent is hereby also directed to mention the actual date of commencement of project on, it will be Onupama Heights, wrongly typed, or Annapurna Heights, and the details of registration of the project under WB RERA, enclosing the certified copy of the registration certificate as obtained from the WB RERA upon the submission of the application related to the instant project, namely Onupama Heights, if the same has not been. Further, the authorities hereby pleased to pass an ad interim order of injunction restraining the respondents from changing the nature and character and or alienating or creating a third-party interest by selling and or handing over any flat of the project. Now, my lord, they are constantly changing the nature and character of the project. They are constructing the project.
Why are you here?
My lord, I have filed an application under section 42.
Yes.
40 subclause 2, my lord. That is also annexed to the application. RERA is not taking up that application. Where is my remedy, my lord?
You go before the civil forum, the civil revisional court.
But my lord, I kindly acknowledge, my lord, tomorrow, if they construct the project in its entirety, my lord, the order.
By one day, the project will be constructed in its entirety. Come tomorrow.
My lord, grateful lordship.
Yes.
On the last occasion, you lordship directed me to.
I'll tell you, Lordship, 19th May 2023. There was an order of injunction, detailed order that was passed, restraining the bank from, apart from other things, from invoking the bank guarantee, my lord. That was there. Kindly have a look at the order, my lord.
Last
order. 2nd September.
6th of 8th, no, not I'm sorry, my lord. Second, page 7 of my supplementary affidavit. 19th of May 2023. 19th of May 2023, page
Yes.
7, Your Lordship will find the order.
Yes.
Well, there's a detailed order, Your Lordship will consider, everything was considered, all the clauses.
Yes.
Well, paragraph 7, kindly have a look at it, page 9.
Yes.
Page
Railway
9, paragraph 7. Hence, before the respondent authority is given a chance to respond to the allegations made, the respondent railways shall be restrained from acting in terms of the impugned notices, including the notice of termination of 25th February 2023, or forfeiting the secure deposit, or encashing the performance bank guarantee of the petitioner. Well, this order is of 19th of May. They were informed twice thereafter. Well, in July 2025, without taking a vacating of this, without questioning this order, without filing an affidavit, they've gone ahead and invoked the bank guarantee and forfeited the security deposit. My only prayer before Lordship today is kindly direct them to, because they're in, I'll take out the contempt, but because there is a non-compliance of this order, let them secure this money in court. That's my
Although this
only
is not
prayer.
the case, my lord. Your lordship kindly see the pair of the main petition, my lord. Specific prayer.
But he'll first explain how he's violated
but
the order
you-
of court.
That is not a violation. You lordship kindly see that instruction, my instruction, my lord. Only, my lord, clause 62 have been employed this case, my lord. That is the case. This is not a violation. Any expert order has been, my lord, initiated by 1 year back, my lord. No, my lord, no, my lord, contempt application has been, my lord, filed, my lord, by on behalf of petitioner.
Okay.
Only supplementary evidence. You can see my instruction, my lord. That
কি আছে ইনস্ট্রাকশন আমাকে দেখান
কোর্টকে দিয়েছি করতে।
আরে তা আমি বলবো কি করে
আমি তো এমনিতে দেখাবো। তোমাকে পাঠানো হয়েছে তো। পাঠানো হয়েছে।
There is an in-house dispute resolution mechanism mentioned in the contract itself. Why are you not availing that
because
facility?
well, that is this complete arbitrariness in how they've gone ahead. Well, now the issue
Why will the writ court enter into all these contractual
is because
disputes?
it's ex facie. Your Lordship may have placed this order of 19th May. But one thing Your Lordship will consider, 19th of May 2023, this order is passed by this Honorable Court. The respondents today probably will have to come and first explain how, despite this order, they're acting in breach of it. There are other issues if they want to rake up.
What exactly is the order?
Malad,
You read out just now?
yes, Malad, page 7 of the supplementary
Yes.
affidavit.
Page 9,
Before the railways is given a chance to respond to the allegations, the
railways shall be restrained
Yes.
from acting.
And for more than 2 years, you are enjoying it.
Malad, that's right, but this order is still in vogue, Malad.
Yes, yes.
The railways
This
doesn't
order-
come up. This order has been passed. The railways hasn't preferred a vacating application.
No, no.
They haven't filed an appeal. Well, if the
There is no
railways can't
question
come
of
and
an
tell the
appeal
court that
because-
despite the order is there, I'm going to violate it. That is the first thing they'll have to then, they'll have to cross that hurdle.
File the contempt if you choose.
No, that
And what are you doing with the performance guarantee? You've used it.
So let them
That
secure
is
the money.
on 25th of February 2023, Mala. You should kindly see that order. 23, Mala.
You invoke it in 23?
Yes, Mala. This is this case is 23, Mala. 2 years back, Mala. This is 2 years. You
That's
should kindly
the
see
notice
that
of
number.
No, that is the
Notice of
termination.
Yes, yes, Mala. Termination.
What about the invocation of the personal guarantee?
Invocation, Mala. That is, Mala.
Of the performance bank guarantee. That is what they've invoked now in July 2025.
That is, Mala. You should kindly come to Mala. My instruction, Mala. That is para 1. The order of forfeiture performance guarantee security deposit was already issued from the office of
Correct.
Deputy Chief
This is
Engineer,
what has been stated.
Northeastern Railway, Lucknow, on 25th of February 2023.
Show me the 25th February 2023 order once.
Then, Mala, this is before interim order of the Honorable High Court dated to 19th.
One minute. Please show me that order. 25th of February 23.
Yes,
Impugned
I'll
order?
show that. Yes, this Your Lordship will find at page 272 of my writ petition.
Yes.
Well, the instruction, if I could just take a look at, well, it says it was passed before the order was passed. That is what has been stated. At 273, Your Lordship will have a look at once. And this is the stay, it's Unimaginable. A railway is come and saying that despite this order, I've done it 25th February 273, last paragraph. Since the period of 48 hours notice is already expired, the above contract stands resigned in terms of 62. Balance work under will be carried out independently without your participation. Your participation as of every member in any manner as individuals is hereby debarred from participation in a tender, and your secure deposit shall be forfeited and performance guarantee shall also be encashed.
Yes.
Well, this stay was granted because the contract requires a notice period within which this has to be done.
Stay was in May, right?
That's right.
And this order is in February.
February.
And within February to May, nothing happened.
Nothing happened. The bank guarantee was still alive. It was with me. In fact,
Your
the
Lordship,
railways doesn't. Acme, the railways doesn't. I saw his instructions.
Did you file the opposition?
Yes, no option.
Why?
I will file my Lordship.
So from 23 till 25, you didn't
Because my Lord,
file
I am
opposition.
not getting my notice, my Lord.
What
Because
notice?
This is Lucknow, my Lord, Calcutta, my Lord. My preliminary objection is that my Lord, jurisdiction, my Lord.
Lord,
Arbitration clause is there, my Lord.
But all that.
My Lord, this matter, my Lord, totally, my Lord, baseless. Because, my Lord,
So he'll violate
yes,
the
my
order
Lord.
of
Because, my
court.
Lord, Your Lordship, what violation?
Without
violation.
Well, he doesn't come up.
After passing
I don't know
2
why
years.
he
The
screams.
cause of action arose where?
Was
Lord,
in Lucknow, my Lord.
No.
Here,
This is
look at page 273. One.
Calcutta, my Lord, connection.
Page 73.
Page 273 kind.
Page 73.
Page 273 kindly have a look at.
73.
Well, the contract was entered into. Well, then let him place his case. I don't know if he's going to somehow justify his complete violation.
I can, my Lord, keep silent, my Lord. Then petitioner.
What he has notice to be given to you, but no action taken in progress. Yes, 273.
273, your lordship has seen?
Yes.
My lord, here this notice was issued there, received by me here. The contract goods are being supplied from me here. My notice of termination received within. All notice of inspection received within. My lord, today a party is in breach of an order of court. For 2 years, he doesn't do anything. He's received notice. He doesn't come and tell the court that I am not the party involved.
Please come.
In complete violation, kindly direct them to secure the amount. My lord, I'm
opposition, my Lord.
This, your lordship will not sanction this, this violation of
How can be for contempt?
Punishment.
The report filed by the Deputy Chief Engineer / Construction -111 Northeast Railway, Lucknow, dated 10th September 2025, filed in court is taken on record. Stop. The respondents have encashed the performance bank guarantee, which was secured by the petitioner. Stop. The petitioner prays for a direction upon the authority to secure the money before this court. Stop. It appears that the respondents were restrained from acting in terms of the impugned notices, including the notice of termination dated 25th February 2023, or forfeiting the security deposit or encashing the performance bank guarantee of the petitioners, till the respondents respond to the allegations made by the petitioner. Stop. The respondents have not filed their opposition till date. Stop. The respondents are directed to file their affidavit in opposition within a period of 8 weeks. Reply, if any, within a fortnight thereafter. Stop. Liberty to mention the matter for hearing. Stop. The fate of the performance bank guarantee shall abide by the result of the writ petition.
Lord, the money that has been taken
Yes,
by them in
whatever it
violation
is,
of an order of court, Lord, that your lordship will
that
direct
will
them to
depend upon
secure,
the that will depend upon the
Lord,
fate
that
of
is
the
in action will depend. Lord, in the face
call the
of an
next
order
matter.
passed by this court, they'll violate it and go away.
The next matter. Yes.
My lord, I am appearing
Yes.
on behalf of the petitioner. My lord, this kindly sees the last order dated
My lord,
20th
may I
of
file a
August
report?
2025.
Yes.
Paragraph 4.
My lord, may I file a
State was directed to file a report. Paragraph 4 kindly sees, my lord, how far they have proceeded. Whether any committee has been.
also
Yes.
appeal. So he will see
how far we have progressed?
Yes, minutes of last 3 years shall be placed.
Last 3 years?
No, minutes of last 3 years. But no, sorry, মানে আছে আমি জানি না ঠিক।
নেই।
Oh, minutes of last 3 years নেই।
যা আছে দিয়েছি।
No.
Yes, what steps have you taken?
My lord will see the report, my lord.
Yes, which portion to see?
My lord, the meeting was held on an emergency basis. Thereafter, the
Emergency basis?
My lord,
What was the emergency? The court's direction is passed long back.
Your lordship was the
alerted
emergency.
the government about this issue.
Yes,
My lord, this matter has alerted the government about the issue.
this matter alerted the government. What about the earlier orders?
People have been given, my lord will see the report.
Place it, which portion to be seen?
My lord will see paragraph 5.
Yes. That is September 23.
5, 8, my lord, then 13, and my lord.
Go through the report. Come back.
My lord, I have just gone through the report, my lord, just now.
Yes.
We have not complied your lordship's order, my lord.
Which
3 years, 3
is
years.
not here.
No, my lord, not here.
What is the explanation given? This also you see as to why it has not been given.
My lord, grateful, my lord, grateful.
A report in compliance of the order passed by this court,
Huh?
filed by the.
My lord, let it be pending so that her
Officer in charge, Law Cell, comma, Directorate of Correctional Services, dated 10th September 2025, be taken on record. Stop. Copy of the same, handed over to the learned advocate for the petitioner in court today. Stop. It will be open for the petitioner to file an exception to the same.
Grateful, my lord.
Release the matter on 3rd of November.
3rd November. Grateful, my lord. Part-heard কোন আছে? ইয়ে আছে, part-heard আছে এটা? My lord, part-heard, my lord, because I do not know, my lord.
It cannot be part-heard. I don't keep matters part-heard.
Grateful, my lord.
exception নাও, আমি তোমায় exception নেব।
May I please your lordship?
For the respondent number, private response takes now.
My lord, pursuant to your lordship's earlier direction, my lord,
Yes.
it was directed, my lord had directed me to serve the PWD authorities.
Yes.
Ascertain the ownership of the land, my lord. I served, my lord, on the earlier date. Affidavit of service was given on record, my lord.
Yes.
And my lord, the service surprisingly came back refused, my lord.
By the PWD?
Yes, my lord.
The state is here.
My lord.
All right. Yes.
Unauthorized construction.
Unauthorized construction.
I've taken one telephonic instruction. The written instruction has not yet.
Is the petitioner the responsible for the unauthorized construction?
Kindly come to page 19.
19.
19.
That is
the
before my
finding
learned
of the-
friends place the case, my lord, may I place my case, please, my lord?
Yes.
My lord, may kindly comes to page number 13 for once, my lord.
Yes.
My lord, the road is recorded as Rasta and it is recorded in favor of Paschim Bongo Sarkar Pokkhe Collectorate. Now, my lord, the road belongs to the collectorate. Now, my lord, there was a subsequent 144 proceedings.
No, you tell me whether you are making the unauthorized construction
No,
or
my lord,
opposing.
No, my lord, I am.
Are you opposing?
No.
Are you opposing the unauthorized construction, or you are responsible for making the construction?
My lord, the entire lease revolves around an encroachment. The encroachment which I have not made. And the Panchayat also declares that. Panchayat has 2 stands, 2 orders. The first order is that the encroachment needs not to be removed. And the second order is that the encroachment needs to be removed. Subsequent direction by this honorable court, my lord. Now, my lord, kindly comes to page number 24.
What is the immediate challenge? Please show me.
My lord, the immediate challenge is that, first of all, my lord has recorded a detailed order. In the last order, my lord has recorded. Now, my lord, my 2.
You are Jan Mohammed Mullah.
No, my lord, I am Indrish Mullah. Jan Mohammed Mullah has deceased, my lord. I am the other.
Indrish Mullah. That
Indrish
means page 30, you are the notices.
Notice,
and you have been directed to move out.
But my lord, page number 24, that was without any hearing.
There is one line order, my lord, page
Please
number
come.
24 once.
No, nothing.
My lord, page number 24 once, my lord, that is not a reason order. I have not been given a hearing. But in a hearing where I have been given a hearing, my lord, I have not met the unauthorized
Petitioner.
construction.
The
My lord, may
petitioner
kindly
has
comes to page
been
number 24 once, man.
found to be in
My lord, may kindly comes to page number
but
24 for
the
once, my lord, before
petitioner
dictating any
has
order, my
been
lord.
found to have constructed illegally over government plot of land. Stop. Notice have been given to the petitioner. Notice has been given to the petitioner. Achha, how
My lord,
many
that was without hearing me, my lord. With
petitioners?
hearing me, page number 24 is my hearing order, my lord.
Petitioners to vacate the plot. Stop. The petitioner is aggrieved by the same. Stop. According to the provisions of law, a private party is not legally entitled to raise construction over government plot of land in the absence of any sanction or permission from the government.
My lord, I have that permission, my lord. My lord, may kindly.
The,
my lord, I have that permission, my lord.
where is the permission?
Page number 24 kindly comes, my lord.
I am at page 24.
My lord, kindly since Panchayat has permitted me.
What
My
Panchayat
lord,
has
kindly
permitted
last
you?
paragraph, my lord, page number 24.
Yes.
অতএব সমস্ত কিছু বিবেচনা করার পর এই সিদ্ধান্ত নিলাম যেহেতু মামলাকারী দাগ নাম্বার 726 729 উপর বসবাসকারী জাহির হোসেন পিতা জাফির হোসেন ও তার পরিবারগণের চলাফেরার কোনো অসুবিধা নাই তাই দাগ নাম্বার 730 উপর থাকা বাড়িটি ভাঙার কোনো প্রয়োজন নাই।
It is in 24.
And
now this has come in 25.
This order has not been set aside.
19.
Well, this order has not been set aside.
19.
This order has not been set aside by any
LLR's
forum.
finding is totally different. Pradhan's finding is totally different.
Well, this order has not been set aside, and my lord, how can the Pradhan's order sustain in this matter?
The petitioner.
Well, I have petition, my lord, on that score.
Relies upon the order of the Pradhan of the Gram Panchayat dated 17th January 2024.
This was also passed pursuant to the direction of the of this honorable court.
In support of the submission that the Pradhan permitted the petitioner to hold on to the construction that has been made. Stop.
And it was pursuant to the direction of this honorable court, my lord. My lord, may kindly see the first line of the order. Subject matter WPA 7509 and 2023. Pursuant to direction of this honorable court, the Pradhan has passed an order.
It appears that the executive magistrate Rampurhat,
Page 19.
Page 19.
by an order dated 16th of September 2022.
My lord, that has been stayed, my lord. May I indicate, my lord, that has been stayed by this honorable court.
Directed the Pradhan to measure the obstructed portion of the government road. Stop. According to the petitioner, the measurement was made without granting any opportunity to the petitioner. Stop. Paragraph. As the petitioner contends that the petitioner is not occupying any portion of the government road, accordingly, the Block Land and Land Reforms Officer, comma,
And I've served the Block Land and Land Reforms Officer also, my lord.
the
My lord,
Public Works Directorate and the Gram Panchayat are directed to conduct a joint spot inspection to ascertain.
That order has been passed.
Joint?
Yes, my lord. Kindly see. There is a contempt proceedings.
Let me
and
see.
their contempt proceedings, this order, my lord, kindly see.
my lord, that order has not been, what order, my lord?
What order? You are present over
No,
there.
no, I am not present. I have no knowledge of
State
such order.
party. I was the petitioner.
Whereas the video has forwarded letter of the Pradhan.
My lord, I am not aware of any such order, my lord. Otherwise, I would have annexed in the writ petition, my lord.
Contempt proceedings, he could not appear. In
No,
the
contempt.
petition,
There was
he
no
appeared.
there is no
he
contempt
failed.
against me.
Now he is taking all
No,
this.
there is no contempt against me.
Connivance with the Pradhan.
My lord may show any service. My lord, let them show any service upon me, my lord.
Issue over here.
No, my lord, I have not been served. I have not been heard with regard to any order that they are showing, my lord.
Acha, oita katun to last line ta katun.
My lord may kindly, my lord may kindly direct my counterpart to serve me a copy of the order, my lord.
না শুরু করলাম কি দিয়ে ওটা কেটে দিন
My lord, may kindly directs the copy of the order will be served upon me, my lord.
Suppressed before your lordship.
No, I have no copy
This
of the
is
order,
not-
my lord.
The
My lord, may kindly directs them to serve me a copy, my
learned
lord.
advocate representing the private respondents produces a copy of the order of the subdivisional officer, Rampurhat Birbhum, dated 18th August 2025,
Order.
wherefrom it appears that
My lord, a copy of the order be served
The-
upon me, my lord. I have no copy
Public
of the order.
document. You can get it from the.
police has been directed to remove the unauthorized construction that has been found. Stop. Next. The same. Now, the said order was passed upon compliance of the order passed by this court.
My lord, may kindly see copy two portion of the order, my lord. My lord, may kindly see the copy
31st
two portion of
July
the order.
2025.
My lord, may kindly see the copy two portion of the order, my lord. I have not been served with the copy of the order.
WPCRC 121 of 2025, arising out of WPA 7509 of 2023. Stop. The the official respondents would be bound to act strictly in terms of any order passed by this court and remove all unauthorized encroachment over government plot of land. The writ petition stands.
My lord, the copy of the order be served upon me, my lord. My lord, may kindly see the copy of the order has not been served upon me, my lord. Kindly see, my lord, the copy to option. My lord, kindly see the copy of the order has not been served upon me, my lord. See, I have not been heard while the order was heard.
You go before the bench which passed the order.
My lord, may kindly direct the copy of the order be actually served upon me, my lord. I have not been heard, my lord.
না
But I have not been
দুজনের
heard,
কেউ নেই
my lord.
ছটার ভেতরে বাড়ি চলে যাবে কি করে কাজ হবে আমার
My lord, my lord,
I am for the petitioner, lordship.
Item number 7, I'm led by Mr. Joint to Shan. Come to the state, my lord. He's on his leg, court number 30.
but then you are there. Yes.
Lordship,
Yes, please.
lordship, can recollect that the work order was issued on special case, that matter. And lordship directed the council to take instruction as to when they will.
The instruction.
Lordship, my humble instruction, lordship.
There is a mention of the stay order
Lordship.
by this court.
Last occasion, lordship, I
Yes.
submitted that. And lordship, in 2024, state was directed to fix a rate. Till date, they have not fixed rate for inviting tender, lordship. That is the difficulty.
State.
State means directed, lordship. Directed to fix a rate, lordship.
Complicated.
No, lordship, why stay, lordship? That is the reason, lordship. Can you see that this order, lordship? That is the parent order, lordship. Can you see?
Please come.
May I submit one thing, lordship?
See,
No,
it
lordship,
is absolute
I have
temporary.
challenged the work order issued to them without
It's not a work order. It has been mentioned that it is.
lordship, one thing, lordship,
mentioned-
lordship, kindly see, lordship, page 144. In this situation, what should be done? The state government has guided it. Lordship, kindly see page 144, lordship.
Yes.
Sorry, 147, I'm sorry.
Yes.
Lordship, first one, laying down the comprehensive procedure and guideline for accepting the bids under different situation, covering all the aspect of the tender outcome has under the active consideration of the state government. And Lordship, what has stated, Lordship, at page 149. In addition to what has been stated in situation 1-2, I am not for item divisible in nature.
No, this is not a regular work order.
But Lordship, they have issued work order without
It is
any.
mentioned over here that the expression work order has been used only for facilitating payment.
Lordship,
it is not a regular
My
work
humble
order.
submission is why they have chosen that respondent, that part.
It is only because of the distance
No,
factor.
Lordship, I am just going your distance, Lordship. My distance is shorter than that, Lordship. Lordship,
The-
may I suggest one thing, Lordship? Let the persons applicant there, let them check their credential and issue on the tender, issue the work order.
They cannot because of the stay
No,
order.
Lordship,
of
this is
the
not that.
court.
On the earlier rate, Lordship, the applicant has given an application that I want to work on earlier rate. 2-3 applications are there. Let them decide on the basis of credential, Lordship, because credential is the main thing. Credential is the main thing. They do not have that credential.
The Chief Medical Officer of Health, Bankura, has
And
forwarded
pick and choose, Lordship. It's arbitrary.
a note dated 4th September 2025, clearly mentioning that that due to expiry of the existing contractor on 31st July 2025, it was necessary to engage a new service provider. Stop. The authority considered the case of one Photik Chandra Mondal, the petitioner herein Shiva Prasad Banerjee, United Order Supply Cooperative Society Limited, and the self-help groups. Stop. A tender committee meeting was held on 22nd July 2025 to review all the options. Stop. As per the direction of the Secretary, Health and Family Welfare Department, the CMOH was directed to propose suitable action for by using a tagging order. The first alternative available was Sri Photik Chandra Mondal, from whom consent was sought for. Stop. As the said Photik Chandra Mondal accepted to a temporary arrangement by way of tagging only for 6 months until finalization of the fresh tender, the said person has been permitted to make the necessary supply. Stop. The expressions, the expression within quotes, work order, has been used solely to facilitate treasury payments made against the submitted bills. Stop. The authority accepts that the same is a temporary arrangement and fresh e-tender will be floated. Stop. However, due to an existing stay order on cooked diet supply, necessary direction is required to be obtained from the Honorable High Court. Stop. Next. The paragraph. The petitioner asserts that the temporary arrangement has also been made by adopting a pick and choose method. Stop paragraph. The court is not inclined to exercise jurisdiction in this matter at this stage, as the supply is to be made to the hospital on emergency basis, and there can be no and the procedure adopted is a mere stop-gap measure. Stop paragraph. The respondent authorities are, however, directed to take steps for floating fresh e-tender for selection of the suppliers in accordance with law.
Lordship, one thing, Lordship, they have mentioned in the report that for 6 months, Lordship, then after 6 months, they will choose new incumbent, Lordship. Let them direct.
Obviously, that is what it means.
Lordship, reflect in the order sheet, Lordship, that is after for 6 months. It should be restrained up to 6 months, Lordship.
I do not know if the stay order continues. How will they?
No, Lordship, the second applicant will be allowed then.
You make submission next time.
Lordship, then Lordship, kindly direct them to give me the copy of this report.
Give.
What?
Report.
Report.
Circulate the copy.
Much obliged.
Yes.
Item number 8.
Wait, my lord, I'm appearing for the petitioner. My lord, this is that matter where we were challenged an order passed under section 14, my lord. The respondent bank, my lord, was of the view that if we pay the 9,26,000, if we pay up 9,26,000, they would settle the issue, my lord. My lord, this is the supplementary order disclosing that we had paid all, my lord.
All means 926.
926.
All right.
My lord, this.
926 not paid.
First of all, my lord, they did not comply with my lord's order. My lord's order was to pay 5 lakh by 22nd of August and then remaining amount by 30th August. That has not been done, my lord. On the next day, only 1 lakh was paid, my lord. And moreover, this first document of 2,36,000, which my learned friend has annexed in supplementary affidavit.
Where is the supplementary?
This check amount is not appearing.
No, this is RTGS.
This amount is not appearing in the statement of account of the company, my lord. Let them furnish proof that this amount has actually been created in the account of the company, my lord. I am here with the statement of account, my lord. This amount would not find a place. 6,90,000 I am admitting. But
RTGS, is there any scope that you do not get it? It's an online transfer, isn't it?
It's not appearing. They are claiming it's RTGS, my lord.
Yes.
It must appear in.
Certainly, if you have paid, then it should be reflected.
Yes,
That event, what I say, Myla kindly keeps it on Monday. I'll bring that my statement disclosing that the payment has been. This only remains.
That particular account.
Certainly.
And well, the stay was still the first. I have not, on the last occasion also, I have not renewed my prayer for stay, my lord. That is not.
But then they are not taking steps and you did not act.
No, I say I have paid. There's a dispute with like 2,36,000. Whether
no,
they
not only 2,36,000, the date,
yes, not
the time period within which the money was to be paid.
Yes, my lord. I have also disclosed that, my lord, in my supplementary page.
Please take up and come back. Suppose the money is there with you, this disputed amount, then is it all right?
Yes, my lord. I will again take instructions from my client.
Monday, my lord.
By
Monday.
You intimate today itself.
Yes, my lord. As soon as I get it.
If it's as soon, if you can do it immediately, then why wait till Monday? I can keep it tomorrow only.
If they furnish any document, I can come back with it.
Yes.
For getting that statement, I have called my client up. He said that he has paid up. Now I asked him for the statement. He said me, I'll get it by Monday, 10:30 to 12. That is why I'm praying for Monday, my lord.
It is you who is in default.
Yes, my lord.
And it is you who have to be active.
Yes, my lord.
And if you keep waiting, I'm going to vacate this stay. You say you've paid, the bank has not received the money. The bank will proceed.
Monday. I'm only praying for Monday, my lord. Today is Thursday. I'm praying.
Monday, hardly court will be there after 12.
My lord takes up matters or at 10, but not takes up origins matters 11 till 11:30. We still have some time, my lord.
I have Monday to be mentioned. Ashwin to the supplementary affidavit filed by the petitioner is taken on record. Stop. The bank disputes payment of rupees 2.96. Now 2.36. lakh.
690 is admitted, my lord. 2,36,000 is.
Paid by the petitioner in the account of the bank in respect of the subject loan. Stop. Learned advocate for the petitioner seeks time till Monday, on a 15th, released on 15th, under the heading to be mentioned.
It's a financial institution, my lord, bank. It's not bank.
Oh, not the bank, it's a financial institution.
Give to the-
Paid to the bank, no? Financial institution.
Madam, for the meeting.
My lord, I am appearing for respondent numbers 4 and 5.
Affidavit of sir.
State, yes.
My lord, relationship manager of ICICI Bank defalcated 38 lakhs from the petitioner. But I have made an application before the ombudsman when bank did not act it within 30 days. But kindly takes up page number 30.
Page number?
30.
Yes.
Now, my lord, my application was rejected in limine without any hearing. My lord, closure clause is 16(2)(b), the reason. Now, my lord, kindly comes to 16(2)(b), that is appearing in page number 42 of the said scheme.
Yes.
But may I read? The deputy ombudsman or the ombudsman may reject a complaint at any stage if it appears that the complaint made is non-maintainable. Clause 10. I'm reading my letter 16(2)(b) now. The ombudsman may reject the complaint at any stage if his opinion is there is no deficiency in service, or B, the compensation shortfall for consequential loss is beyond the power of the ombudsman to award the compensation as indicated in clause 8.2. Now, my lord, kindly comes to clause 8.2, that is in page number 35. Now, my lord, clause 8.2, power and function. 8.2 is there is no limit on the amount in dispute that can be brought before the ombudsman, for which the ombudsman can pass an award. However, for any consequential loss suffered by the complainant, the ombudsman shall have the power to provide compensation up to 20 lakhs. In addition to up to rupees 1 lakh for the loss of the complainant's time, expenses incurred for the harassment, mental anguish suffered by the complainant. Now, my lord, kindly comes up page number 30 once again. Now, my lord, my compensation shortfall was 3 lakhs. From 1 lakh to 3 lakhs, that has been asked for wrongly. Now, my lord, without considering that, my application has been rejected and there is no appeal clause. Now, my lord, kindly comes to page number 43, that is appeal. Now, my lord, it says appeal before the appellate authority, there shall not be any right to appeal to a regulatory entity for an award issued for non-furnishing of documents, information under clause 15(1)(a), that is not applicable to my case. The second clause is the regulatory entity may aggrieved by an award under clause 15(1)(b) or closure of a complaint from clause 16(2)(c) to 16(2)(f within 30 days. So, my lord, 16(2)(b) is not appealable. I do not have any scope except, my lord, approaching your lordship for reconsideration of my prayer. My lord, I will make fresh application by putting 1 lakh compensation. Kindly gives me that opportunity, my lord.
My lord, may I make one submission?
Yes, please.
Now, your lordship will note that so far as the closure of complaint is concerned, which is dated 26th of May 2025 and which has been averred in the body of the petition, that has not been disclosed. Now, why it has not been disclosed is because in the closure itself, the liberty was itself granted to the petitioner, stating, I'm just reading it out from the closure of complaint, the complainant may lodge a fresh complaint with RBIO for compensation within the permissible limits. So, despite having been notified of this closure, about which the petitioner is well aware. He has pleaded also to that effect, but he has not disclosed this document deliberately to obtain an order from your lordship. That order, what has been sought for, if your lordship kindly turns now to page number 17 of the petition.
Yes.
It off or in the nature of fresh and or enabling your petitioners to file a complaint afresh. Now, this enabling is already there in the closure itself. So why am I
No, it is not there. It is not there. Inclusive.
falling back, if I may just ask it, liberty to, he was already given the liberty to file afresh. He was
But
already
was
given
that-
the liberty to
was
file
that-
afresh.
was
And that
that
is specifically there in the closure.
Was that communicated to the
Yes,
petitioner?
yes, most
Both
certainly.
are.
Yes, yes, your lordship.
There in
That
the
was
portal, I have any page number 30. Kindly see.
Why is my learned friend falling back on the portal when, because your lordship will note what he has done very interestingly, what has been disclosed is only the complaint which was lodged and the complaint tracking. It's like a receipt which is issued after you lodge a complaint. So that is at page number 29 and 30, which
Do
was
you
placed
have
before
a
your
copy?
lordship.
Do you have a
Yes,
copy?
I do have, but your lordship will also appreciate that they have pleaded it to the effect at paragraph number 25 that in closing the complaint in limine without going into the merits of the complaint dated so and so, the closure is dated such and such. All these is written in the body of the petition. So he could not have got the information if he wouldn't have been made aware of it. Kindly
Page
turn to
30
paragraph
from
number
the
16.
portal, he gets to know it. Page 30
No, your
is
lordship will
there.
kindly turn to, no, your lordship will kindly bear with me for a moment. Paragraph number 16. Paragraph number 16 at internal
The
page number
petitioner is
10.
aggrieved. Petitioner is aggrieved by the unilateral closure of complaint made by the petitioner before the banking ombudsman under clause 16 within bracket 2 within bracket small b of the Reserve Bank hyphen integrated ombudsman scheme, 2021. Step. The petitioner admits that the complaint was made for an amount which the ombudsman doesn't have the authority to direct payment. Step. The petitioner
Compensation, kindly see. That compensation part only.
compensation amount যেখানে বললাম ওখানে compensation amount. The petitioner seeks leave to file a fresh complaint. Paragraph, learned advocate representing the ombudsman submits upon instruction that the closure of complaint clearly mentioned that the petitioner would be at liberty to file fresh complaints within the limits as prescribed, limits of the ombudsman as prescribed in this scheme. Stop. Learned advocate for the petitioner submits that the petitioner was not aware of the communication allegedly made by the ombudsman. Paragraph. Be that as it may, as the ombudsman permitted the petitioner to file fresh complaint. Accordingly, the instant writ petition is disposed of by observing that it will be open for the petitioner to file fresh complaint strictly in accordance with the subject scheme. Writ petition disposed.
Grateful.
Service taken
Grateful
of
to
record.
lordship. It was communicated by email dated 26th of May.
Good.
My lord, may I please your lordship?
And for the response number 5, your lordship.
My lord,
My lord, I'm appearing for this.
very
State.
short matter, my lord. A section 14 order has been passed by the district magistrate, which was assailed. My lord, before that, the one very important fact to be noted is that it's a two-storied building, wherein the ground floor and the second floor is mortgaged with the bank. First floor is not mortgaged. Defaulted, we moved a section 14 application, section 14 order granted. Now, the wife of the mortgager lives in first floor. She challenged that section 14 order before Death Recovery Tribunal, stating that my ingress egress getting affected. Death Recovery Tribunal passed an order stating that the order is absolutely correct, not interfering, and directed bank not to interfere with the ingress egress. Upon getting that order passed by the Death Recovery Tribunal, we filed a caveat so that no further suits or anything gets filed. That caveat was filed upon the mortgager and the borrower. All of a sudden, a person cropped up stating himself to be a tenant. He serves me a copy with a plaint wherein bank is never made a party. A suit between a tenant and my mortgager, completely a setup tenant. And surprisingly, he served me a copy of the plaint wherein he does not make me a party. I replied by stating that I am not a party. Why should I go into your plaint? Then he moves us before the civil court and obtains an order against the borrower or the mortgager. However, that order does not bind me because I am not a party to the suit. Now I am approaching the executive magistrate to execute my order. Executive magistrate is of the view that since there is an order of the civil court, I cannot. Wherein executive magistrate is not.
Why have you implemented the executive magistrate by name?
Because that is the person who has been appointed as officer subordinate in the section 14 order by the DM. So he is the person responsible to execute the order as per the order of the DM. That's right.
Your Lordship, may I?
So, my lord,
just wait. Yes.
So, my lord, the district magistrate has completely passed an order under section 14 that has completely been upheld by DRT. The executive magistrate being an officer subordinate who has only been nominated by the.
Did you annex the plaint over here?
Yes, my lord. My lord, may kindly come just 2-3 pages. 128 is the caveat because this is very important that the bank has lodged. Kindly come to page 128 once.
Yes.
128, my lord, will find the name against whom the caveat has been lodged. All my borrowers and the guarantors. Now, my lord, kindly come to the injunction order that has been communicated at notice. That is page 155. Here, this person, advocate, is writing directly to us, stating on behalf of his client Sushanto Pahani, who I have never served a caveat with, and he is not a party. Now, kindly come to page 157. This is the injunction application. Kindly see, Sushanto Pahani has instituted a suit against Ashish Kantipal, who is my borrower mortgager. I am not a party.
Where is the full cost title?
My lord, the full cost title has.
Who are the other defendants?
Full cost title has not been. And kindly see the order that has also been passed by the suit court. Kindly come to page number 187.
Yes.
Here, where it has been misrepresented before the civil court even, and it's a concocted story, completely hand in gloves. Kindly see, it appears, the third paragraph, it appears that caveat has been filed. Plaintiff files separate affidavit swearing that order 39 rule 1 and 2 against defendant as a caveat been lodged by one such and such through its advocate and sent a copy of the plaint. I never lodged a caveat against him. The borrower went ahead, set up the tenant, gave him the caveat, and filed a suit against the borrower mortgager himself. And the tenant and the borrower, they themselves obtained an order wherein Bank of Baroda is not made a party. This order is not valid upon me. And kindly see at page 188, only defendant is directed not to maintain status quo. I am not the defendant. And my lord, since I'm not privy to the entire cost title, but from page 157, it would transpire that there is only one defendant. Page 157, paragraph 2, injunction application. Nowhere it spells about a bank. First,
What is the relief that you are claiming here?
my lord, just a direction upon the executive magistrate to execute the order that has been passed by the district magistrate and upheld by Debt Recovery Tribunal. That's it. Respondent number 3 should execute.
Where is the order of the tribunal?
Debt Recovery Tribunal is, my lord, with 121. Relevant is at page 126. Decisions with reasons. 126. My lord has found that decisions with reasons.
Yes.
Yes. Learned counsel such and such submits that the petitioner with malafide intention motive has filed the petition and that the petitioner is the wife of the borrower mortgager such and such. It is stated such and such, the first floor. It is argued, my lord may skip over. Then 127, first paragraph. It appears that the subject property is a two-storied building comprised of ground, first and second floor, wherein ground and second floor were mortgaged with the respondent bank. However, entrance to the first floor of the said property is common with the ground and the second floor with the stairs, common space are all commonly intertwined with the ground floor and second floor. It also appeared that the intervener applicant has moved a civil court or being titled. This is a separate suit altogether by the wife who moved, which is pending for trial till the disposal, and the respondent bank has been made a party to that procedure. I think that the respondent bank will comply with the order of the civil court, but I am afraid that I cannot injunct the respondent bank from taking physical possession of the ground and first floor, which are mortgaged with the respondent bank. Bank is directed to take physical possession, not to disturb the easementary right of the intervener applicant in respect of her enjoyment of the property of the first floor, which is admittedly not mortgage with the bank. So section 14 order completely upheld. Now, when they have the borrower failed in stopping the bank from doing this, he set up a tenant. Does not make a bank a party in between themselves, got an order. Now the executive magistrate is saying that I will not execute the order. My representation to the executive magistrate is at page 191.
Yes.
So I have sent him a representation.
Where is the section 14 order?
Yes. Section
118.
Yeah, 118. And I'm completely saying that ground floor and second floor is mortgage. First floor is obviously I'm not interested. That is not mortgage. And DRT has also clarified that thing.
Has any time limit been fixed?
My lord?
Time limit been fixed?
No, my lord. Because section 14 orders are valid until it is executed.
It has will instruct.
And my lord, at page 120, second last paragraph, my lord will find the name of the executive magistrate whom my lord has asked me why I have made by name a party. His name is specifically mentioned in the third last paragraph from the bottom.
See, the magistrate can change. So it was not required that
I'm completely
you are.
Whosoever, my lord, let the
whosoever is there will.
My order, and DM should ensure that.
Yes, you are representing.
I am representing the guarantor, respondent number 5, Your Lordship. I am the owner of the first and third floor, Your Lordship. Your Lordship, I would indicate few things, Your Lordship.
First floor is out.
Ground and second floor, Your Lordship. Ground
Not
and
first and third.
Yes.
Ground and
second is mortgaged.
Mortgaged. Yes, Your Lordship. First thing, Your Lordship, my learned friend has not indicated two things, Your Lordship. Secondly, there is a owner of the second floor, Miss Gargi Paul. She has instituted a suit, Your Lordship. Now the entire building has only
first she is talking about.
Yes, one entrance, Your Lordship, only one entrance. So Gargi Paul has instituted a suit and a injunction application was also being preferred and an order was passed, Your Lordship, page 187. Lordship would
that has been read out.
That I have shown.
That has been read out, isn't it?
No, Your Lordship, no.
Made a party to this. As long as, my lord, it is clarified as per the order of the Honorable Debt Recovery Tribunal that with regards to that injunction order that my position will not be disturbed.
You are in the first floor.
First floor.
First floor, the bank has specifically mentioned it is not under mortgage and the bank has nothing to do.
Well, DRT has already clarified.
Why we come again and again, my lord? The order that we wanted to execute, my lord, there is written that there is no order of any court of law. For that, my lord, I had filed an application. Pursuant to my application, an order.
I didn't get it.
My lord, in the order of the learned magistrate, my lord.
Yes.
We want to execute the
Right.
execution of the matter, my lord. There it is clearly stated that there is no order in any court of law. But that is wrong, your lordship. There is an order of injunction dated.
The magistrate is concerned only about the ground and the second. It is you who's creating confusion. Why are you creating confusion? Why are you poking your nose inside a matter which is not there? It doesn't bother you. You are there in the first floor, which is not under mortgage.
There is common entrance.
But the tribunal has mentioned it. Yes.
Your lordship, that page number was wrong. Your lordship, page number 112.
112? Yes.
Just read the order, your lordship. Today a record is placed before me by way of court of petition.
This is again the same order
Let me just indicate, your lordship will.
she's reading again relate to first floor.
Friend has not.
You are not Gargi?
No.
Do not show it.
Then, your lordship,
What is your stand?
My stand, your lordship, there is another. My learned friend has not shown the tenancy agreement, your lordship. He has annexed the tenancy agreement. The tenancy agreement is at page 1.
Whatever you got to say before the tribunal. Nothing.
Please
come.
Pending the DM order is not recording this, your lordship.
You go before.
My lord, I'm appearing for this state, my lord. My lord, I'm appearing for this state, my lord.
What
My
is your
learned
submission?
jury will hand over the. My lord, actually, it is that on 8/7/25 in presence of police from Ravindra Sarovar Police Station, bank authorities and their advocates and advocate of one Shushanto Foni, who claimed to be the tenant of the ground floor of the said property, went to take possession of the subject property. But in spite of that order of the Debts Recovery Tribunal, that in the same order it is mentioned, the second para of, my lord, second para, the last para of the page, first page of the report, it is pertinent to mention here that by the order dated 9/8/24, the Learned Debts Recovery Tribunal directed bank, while taking possession, not to disturb the easement right of the possessor in first floor of the said premises. In the same order, it is also mentioned that it appears from the subject property is a two-story building comprised of ground, first and second floors, wherein ground and second floor were mortgaged with the respondent bank. However, the entrance to the first floor of the said property is common with the ground and second floor. The stairs and common passages are all commonly intertwined with the ground and second floor. Upon visiting said property, severe obstruction and resistance faced from the advocate of one Shushanto Foni and his juniors, who deliberately refused to provide the keys of the lock and constantly resisted from taking possession.
Yes.
One more thing I would like to indicate, page 120, your lordship, the DM order.
Whereas the bank authorities,
Yes,
kindly
120.
place my case. Kindly don't interrupt.
Paragraph.
Kindly place my case.
Not
Whereas
Please
the
stop.
bank authority.
Please stop. State Council, please stop. Yes.
Whereas the bank authority.
Please stop.
The property is not under lease and tenancy as per affidavit. That is the only wrong statement there, your lordship, because the tenancy is there. That only I would like to indicate.
No,
because
there
there
is no tenancy. It's a
And the suit is
completely a
pending.
setup. It's not even registered.
The-
nothing.
The tenancy agreement is there of the year
Tenancy agreement
2003.
can't be sacrosanct. Let them prove in the trial.
The petitioner prays for a direction upon the district magistrate to take steps for execution of the order passed under section 14 of the SURFACE Act. The petitioner is the bank and the borrower failed to repay the amount taken on loan. Stop. The bank has proceeded to recover the loan amount. Stop. The ground and the second floor of the three-storied structure are mortgaged to the bank. Stop. the occupant of the first floor has approached the civil court to obtain an order restraining the bank from disturbing her possession. Step. The bank has clearly made it clear, has evidently made it clear, has explicitly made it clear that the bank is no way connected with the first floor of the subject property. Step. The Section 14 application. Now, the order passed under Section 14 of the Act by the DM records about the ground and the second floor of the property. Step. Next, the occupier of the ground floor has filed a civil suit against the owner/borrower and obtained an order of injunction on 28th April 2025 in title suit 480 of 2025 from the learned civil judge within bracket senior division 9th court Alipur. Step. The executive magistrate who has been directed to take steps for execution of the order under Section 14 of the Act has refused to take possession of the subject property. Step. The securitization application filed by the borrower before the tribunal is pending. Step. The tribunal passed order on
30th April 2025.
Where does the order start?
Page 121.
April 2025. By directing the bank to take physical possession of the secured assets by not disturbing the easement right of the occupier of the first floor. Step. As the bank was unable to recover possession, the instant writ petition has been filed. Step. Learned advocate representing the respondent number 5 refers to the suit filed by the tenant, wherein the interim order of injunction has been passed by restraining the, by directing the defendant within bracket, defendant is Ashish Kanti Pal within bracket, to maintain status quo in respect of the nature, character, and possession of the suit property. Stop. It has been submitted that the bank obtained the order under Section 14 by suppressing the fact of tenancy. Stop. Next. The borrower however, has failed to show any order from any competent court obtained by him in support of his tenancy right. Stop. Specific case of the bank is that the tenant has been set up by the borrower. Stop. The learned advocate representing the state respondents has obtained instruction from the officer in charge, surfaces section, South 24 Parganas, Alipur, wherein the report of the executive magistrate dated 8th July 2025 is annexed. It appears therefrom that the executive magistrate visited the property for obtaining possession, but because of the severe obstruction and resistance faced by the advocate of the tenant and his juniors, who deliberately refused to provide the keys of the lock, possession could not be taken. Stop. The bank identified the borrower who was standing outside, but there was nobody to open the lock. There was nobody to open the lock. Because of the severe argument and brawl which occurred between the parties, the possession could not be taken on that day. Stop. Paragraph. The admitted facts which appear from the case is that at number, the order under section 14 remains unexecuted till date. Stop. The said order, the said order has not been set aside, vacated, or modified by any court of competent jurisdiction. 3 number, the tribunal directed the bank to take possession of the secured asset without disturbing the easementary right of the occupier of the first floor. And 4, there is no order upholding the tenancy right of the tenant of the ground floor as claimed. Next. As the bank has taken steps in terms of the SURFACE Act and an order under section 14 has been obtained by the bank, the bank would be liable. Now, the bank would be entitled to take possession of the secured asset. Stop. The executive magistrate is directed to take steps to take possession of the secured asset with the help of the local police. The police is not a party.
No, my lord. But that order is there.
The officer in charge of the jurisdictional police station is directed to render all necessary help and assistance to the men and agents of the, to the executive magistrate and his men at the time of taking physical possession of the secured asset. Stop. The interim order of injunction dated 28th of April 2024, passed by the Learned Court in title suit number 480 of 2025, is in no manner binding upon the bank. Is in no manner binding either upon the bank or on the Section 14 authority. ঠিক আছে? The occupiers of the ground and the second floor of the secured asset are restrained from interfering with the executive magistrate at the time of taking over possession. Stop. The taking over possession will, however, be subject to any order that will be passed. Subject to any order that will be passed by the learned tribunal in the securitization application that is pending. The writ petition stands disposed of.
I'm so grateful. My lord, the
Gratefully lodge.
has gone down as 28th April 2024, which will be 25.
আচ্ছা 24 বোধহয় বলেছিলাম ওটা 25 হবে
28th April
লাস্টের দিকে
2025.
একটা
I'm so
বলেছি
grateful.
date 2025.
My lord, the affidavit of service.
Yes.
Grateful lodge.
This is against my lord, non-furnishing of information relating to grant received by the Gram Panchayat from Central Finance Commission. My lord, kindly comes to my right to information applications, page 12. First application was to State Public Information Officer, Kharun Gram Panchayat within the jurisdiction of such and such got various financial assets developments for work of central and state exchequer from time to time. I hereby apply as per such and such to provide the mentioned informations as what are the grants that you have got, details of development work for utilization. Next page is they communicate with me and say that the information will be given to you. Please deposit 250 rupees. I deposit 250 rupees, page 14, and that is complete silence. Next is the second application where I specify an amount of total of rupees, page 15, amount of total rupees 1 lakh such and such was spent for the computer, laptop, printer such
No,
and
then
such.
you again sought for information.
Now again sought for information. This is second section 6 application.
And you didn't go up in the first appeal.
There, my lord, this in the first matter, my lord, I
Yes.
was directed to give the money. So they are supposed to give me the information.
Yes.
I deposited the money, thereafter no information. So therefore there will be no first appeal because they are agreeable to give the information. Because they are agreeable and said that please give the money, we'll give. So
Very well,
therefore no appeal.
Page 15 comes in.
Now thereafter page 15 is the second right to information application by an
Yes.
amount of rupees such and such. I hereby apply.
Yes, then page 16.
Next page 16, they say you please, they transfer it saying that you provide the information, and thereafter for providing, kindly see the last line, the said application is given transferred to your office under section such and such, or providing the information directly to the applicant. Next is they again communicate in reference to application you are requested to be present physically on 10/4/2025 at such and such at such and such. This 10th was a Mahabir Jayanti. I go on 11th, thereafter again he is in action. They say that we will be providing you the information, but thereafter they do not. So therefore I cannot go up in appeal saying that the period has expired, so therefore 19(1) will not lie.
Yes.
May I submit my report, my lord?
What does your report?
My lord, may I allow to make a submission before your lordship?
Yes, please.
My lord, please come to the page number 12 of my report, my lord.
I have not supplied with the report.
Yes.
Page number 12.
It has already been delivered to
My lord.
in the office on 28th of February. The application is for same. The copy of the proof is being attached. Where is the information?
My lord, please come to the page number 13.
আচ্ছা কত তারিখে উপেন্দ্র Where is the receipt showing
I'll come
Acceptance
back
by,
with information. If they have given
1
this,
minute.
You decline to sign there, my lord.
He declined to sign. All right, very well. I take it that he declined. Where are the informations? Please show me. Where are the informations? Bring a copy of those informations, all right?
My lord.
If you have given it to the petitioner, you can bring it to the court also.
My
All right?
lord. On very next date, I will bring it. before
Yes,
your lord.
please. The petitioner intends to obtain certain information under the Right to Information Act 2025. Right to Information Act 2005. According to the official respondents, the information was already provided to the petitioner on 28th February 2025. Stop. Learned advocate representing the petitioner seeks to revert with instruction. Stop. Learned advocate representing the state respondents is directed to produce a copy of the information allegedly supplied to the petitioner on 28th February 2025. Released on 17th.
17th.
My lord. Deeply obliged, my lord.
17th
This side.
Yes,
No,
next week.
This one, no, then সামনে show.
Next week. 17 তারিখ।
Well, I am appearing for the petitioner.
Yes.
Well, 12, 13 and 14 are a locus matter, but
Yes.
it's the application made
My lord,
before
I'm
the bank
appearing on item
authority
number 13.
for
I'm being led by Miss Pinky Chakraborty for
educational loan.
in item number 13.
13, 12 you are not there?
I have
12.
instruction about 12. Only 13, my lord.
Well, sharp and this is the
My lord, may I
application
give us the
notice.
bank's instruction?
1 minute. This is 12 going on. Yes, please give the affidavit of service.
Notice and upgradation notice.
When was the application made?
Here, my lord, application was 6 June 25. Respondent number 6. Page 27.
Where is the document to show that it was
Page 20.
received by the bank?
Well,
Received by the bank?
but the bank receipt is application ID, student ID.
No,
That is
no,
the-
receipt by the bank. Bank has received it, this application. Where is it?
It has been uploaded in the portal. That is the application physically made, can be made, and also in the online. That is the rules.
Yes.
Page 21, my lord.
Yes.
Page 23. Yeah. Application will be received either directly, page 19,
Page 19.
at bank branches or through online mode.
Yes, online mode of the bank. You have uploaded in
Receipt of the application, standard acknowledgement giving a reference number will be issued. That is the acknowledgement.
Where is
Then
the
a
acknowledgement?
student ID.
Oh, this is in the common portal and this is not in the portal of the bank. Show me that you have applied in the portal of the bank. Please come.
But, in this way, bank are taking this application, all application. If your lordship direct me to file the another fresh application, then I can do it.
The petitioner applied for obtaining educational loan. Before the Indian bank. Stop. A copy of the application filed by the petitioner in the portal is annexed at pages 27, 28 and 29 of the writ petition. Stop. আচ্ছা লোন বললাম না application for loan under the education loan under PM Vidya Lakshmi Common Educational Loan Scheme, Education Loan Scheme. ঠিক আছে? None represents, submission is that the same has not been considered till date. Stop. None represents the bank. Stop. Affidavit of service filed in court is taken on record. Stop. In the absence of the bank, it is not possible for the court to decide the issue conclusively. Stop. Next. The petitioner asserts that the application for loan was submitted online and a student ID and application ID number has been generated. Stop. There is, however, no proof of receipt of the said application by the bank. Stop. In view of the above, the instant writ petition is disposed of by granting leave to the petitioner to file a copy of the application form annexed to the writ petition before the branch manager of the Indian Bank, Terapakhia branch, respondent number 6. Stop. The branch manager shall take a decision on the loan application filed by the petitioner strictly in accordance with this scheme within the time period as mentioned in the scheme itself. Writ petition stands disposed.
But in my lord, application meant on 26 April 2025, State Bank.
What is your instruction?
13, my lord, we have considered.
You have rejected it.
Yes.
Why don't you let the petitioner know?
We have communicated, my lord.
You have communicated.
Not yet.
We have
Give a copy to him.
I will give a copy, my
You have a photocopy?
Direction may be given to give the copy.
Yes, it was true.
Please come. The petitioner made application for obtaining education loan. ওই প্রথমের পোর্শনটা সেম থাকবে। As no communication was made by the bank, the instant writ petition has been filed. Stop. Learned advocate representing the State Bank of India has received instruction from the branch manager signed on 3rd September 2025, mentioning that the application of the petitioner for student loan stood rejected as the petitioner obtained very poor marks in her previous examination. Stop. Comma. The co-applicant, that is the father of the petitioner, has very poor CIBIL score within bracket 459. Stop. The benchmark for providing loan
Regarding this
should
civil
contain
score, my lord, I have
CIBIL
annexed the
score
order passed by this court.
should be more than 685. And 3, the co-applicant, the mother, is not employed as declared by the block officer Raipur in her income certificate. Stop. Let a copy of the rejection order be formally communicated to the petitioner for taking further necessary steps in the matter. Writ petition stands disposed. Service is taken on.
What
The
is
next
my lord, like as 12? That same bank, Indian Bank, application made on 30th March 2025. The same order for item number 12, madam. Same bank, Indian Bank. This one is number 6.
যেটা 12তে দিলাম সেম অর্ডার হবে এডুকেশনাল লোন সেম স্কিম পেজ নাম্বার ওখানে বলেছিলাম, ওখানে 27, 28, 29, 30। ঠিক আছে, 27, 28, 29, 30 ভাঁজ করা রইলো। সেম অর্ডার।
My lord.
No,
Lord, I know this is not the mention in time, my lord. With your lordship's leave, I mentioned this matter in the morning with regard to the contempt. Your lordship was desirous that I should come back upon filing. My lord, I've opened the number. I just wanted to hand it over to the court if it can be listed, my lord.
Yes, yes, it will be listed Monday.
Monday?
Hmm.
My
Serve
lord, Monday
notice.
perhaps, my lord, subject to your lordship's kind sanction, my lord, Monday perhaps there is a farewell of.
The court will not sit.
I do not know, my lord. My lord, I will take my chance if your lordship is there, my lord.
Yes.
I'm so grateful.
But may I have your lordship's leave? But item number 112 of your lordship's monthly list, but for extension of interim order expiring tomorrow. But
Yes.
I have served notice on my learned friend. There was a miscommunication. We were supposed to mention the matter today morning.
Yes.
My learned senior friend was there, but we missed it. That is why we are mentioning it.
Morning, please mention.
Tomorrow morning we shall mention.
Yes.
Very
Shall I-
With your other side.
Shall I serve and come back, my lord?
Yes, yes.
I'm sorry.
Contempt serve.
I'm sorry.
Hmm.
My lord, I am appearing for the respondent, my lord. The complaint affidavit has been filed, my lord. My lord has passed an order to conclude the disciplinary proceeding.
Yes.
Disciplinary proceeding has been concluded, my lord. Petitioner challenged the disciplinary proceeding also, my lord. The
All
subsequent,
right. Where is the petitioner?
I think he has already challenged the disciplinary proceeding order, my lord. I think he is not interested to proceed.
The affidavit of compliance have you filed?
Yes, my lord, it has been filed, my lord. 16/10/2023, long back it has been filed.
16/9/2023.
My endorsement, it is 16/9.
Is there anything on record? Ashwini? এটা হ্যাঁ whatever আমাদের এটা আসেনি Can you give the writ petition number?
Yes, my lord. WPA 257 of 2021, my lord.
Not this writ petition, but the next writ petition which has been filed.
Lord, I will take.
Challenging the disciplinary proceeding.
Lord, I will give the details, my lord. The chat box before my lord raises.
Can you share the compliance so that we can keep a copy?
Yes, my lord. Yes, my lord.
Please do that.
Yes, my lord.
None appears on behalf of the petitioner. Stop. Learned advocate representing the contemptor submits upon instruction that an affidavit of compliance has been filed. Stop. A reasoned order has been passed, which has been challenged by the writ petitioner in a subsequent writ petition.
Yes, ma'am.
Stop. Learned counsel, you please forward the affidavit of compliance and the writ petition number so that it can be recorded in the order.
Yes, my lord. Yes, ma'am.
All right.
Yes, ma'am.
Right. The contempt application accordingly stands disposed of.
Obliged. Lord, I will file it in the registry, my lord, that both the details. Can I file it in the registry, my lord?
Eta to page. Yes, please file it in the registry.
Yes, ma'am.
And share a copy with us or what? No. The writ petition number, please.
Yes, yes, madam.
All right.
Obliged, madam.
I am appearing for the alleged contemptor. We have
Follow
complied.
up the writ petition number.
Petitioner, my lord.
So that not this writ petition, the subsequent writ petition number has to be recorded. Yes. That one.
My lord, I am for the petitioner, my lord. Here after filing of the contempt application, they have complied with, my lord.
Right. The order passed by the court has been complied with.
My appearance will be recorded, my lord.
All right. Disposed. Record appearance of all parties.
Deeply obliged, my lord.
Three.
My lord, here also, my lord, after filing of the contempt, they have complied with, my lord.
All right. Complied.
Compliance affidavit, my lord.
Yes. Complied.
My lord.
Did you file any affidavit of compliance?
My lord, we have filed on 2nd July.
Both in the other matter also?
No, in this matter, not in the other matter.
In item 3.
Yes, my lord.
Affidavit of compliance has been filed in Port Blair. Let this be tagged. No,
Ma'am.
it is. Oh, it has come.
Yes,
All
ma'am.
right, all right. Let it be written with the records.
Obliged, my lord.
4.
My lord, here I am for the petitioner, my lord. The order was passed on 13/12/2024 for demarcation of the land within 4 months. Till now, they have not taken any steps, my lord.
My lord, we have already, I am for the contemners, my lord. We have already initiated the proceeding, my lord. It is not as simple as my learned sister is saying for demarcation, my lord. If my lord sees my lord's order that we have to demarcate
Will you
the
take?
acquired.
How long will you take?
My lord, it will take some time, my lord, around 2 months more, my lord.
All right, please come. Learned advocate for the petitioner submits that the order passed by the court has not been complied with till date. Stop. Learned advocate representing the alleged contemners seeks further time. Now, submits that the process for complying the court's order has already been initiated and it will take some time to conclude the same. Stop. Next. In view of such submission, release the contempt application on 27th November 2025. Stop. An affidavit of compliance shall be filed prior to the adjourned date.
But they have saying, my lord, they have started the proceeding. We have not given with the any notice, my lord. Till now.
You will get notice certainly.
My lord, obliged, my lord.
Obliged, my lord.
Yes.
My lord, in item number 5, I am appearing for the applicant, my lord. Here
Yes.
The alleged contender, my lord, we have passed the speaking order, my lord, on March 13th, 2025, my lord.
my lord, I am objecting to the same, my lord, because on 11 December
He
2020.
agrees, my lord, he can very well, he cannot challenge this before this contempt proceeding, my lord.
My lord, but on 11 December 2024, there was a specific order where regarding the discrimination part has to be decided by the respondent authorities, but they have failed to do so, my lord.
What is the stand of the contender?
My lord.
What is your stand?
Lord, the writ petitioner has not submitted the requisite documents in the stipulated time, my lord.
Did you intimate the petitioner?
Yes, my lord. It was intimated to the petitioner, my lord.
Yes, then?
And for that reason, my lord, her representation for extending financial benefits of 1/30th of pay was not considered, my lord.
All right. Please come. Learned advocate for the petitioner submits that the order passed by the court has not been complied with. Stop. According to the alleged contender, the petitioner did not submit the requisite documents as sought for. Stop. The contender, the alleged contender, is directed to file an affidavit disclosing his stand. It will be her stand. Her stand. Stop. Actually, give a time limit. By today is 11th. By how soon can you do it?
2 weeks, my lord.
All right. By 9th of October.
My lord. Obliged, my lord.
Released 27th of November.
Obliged, my lord.
My lord. Grateful, my lord.
Item number 1.
Item 1, Jalpaiguri.
Lordships, I appeared, your lordship, for contempt order was complied, your lordship, had already been complied. My one of the junior, your lordships, before your lordships, to hand over the copy of the PPO, revised PPO, your lordships.
Where is
and the counsel of the petitioner. Appear হয়েছে তো? All works.
I am appealing for the petitioner along with my senior
Has the order been complied?
Lordships already complied, your lordships.
Let the petitioner say it.
I am request of my junior lordship hand over the copy of the PPO before your lordship.
I have got the PPO. Petitioner, is the order complied?
Yes, lordships, already complied.
All lordship, it has been complied.
Let this be written with the record. Yes. Disposed of.
Lordships, grateful, your lordship.
Grateful, lordship.
2.
Madam, for the petitioner, time.
Oh, it's first time. Serve. 6th November. 6th November.
Lordship, the Artswell chairman has been made party. He has already been resigned in the month of January.
Is there a fresh chairman?
Yes,
New
Lordship.
incumbent leave to implement the new incumbent.
Councillor, my lord. He has been made party as a councillor, not as a chairman.
Not as a chairman. Is the councillor still there? What is his name?
Shopon Shaha, Lordship.
Is he still there as a councillor?
Yes, Lordship.
Yeah, that is the designation by which he has been implemented. Then it's all right.
Yes, I have not been served. That's why I have not been served with the copy of the contempt application, Lordship.
আচ্ছা 13th করে দিন 13th next
Item number 3.
My lord, I am for the contempt not responded, my lord.
yes what happened
My lord, on last occasion, my lord, I have submitted that this is a
item 3
Item 3.
please unmute yourself Mr. Shingho. What happened? Has the order been complied?
No, my lord. My lord,
Yes.
your lordship's order, my lord, was there, my lord. My lord, it is an issue of single teacher, my lord.
Yes.
My lord, district inspector of school, my lord, forwarded the alternative vacancy to the commission. My lord, commission is not in a position to consider the transfer application of the petitioner. On last occasion, my lord, I have handed over a document of 8th of August 2025.
Yes.
Requesting the district inspector of school to find out an alternative arrangement, and if it is possible, then commission will consider the transfer application. My lord.
Please come. He's for the contempt number 1. Record his presence. Vikas Singh নামটা দিয়ে দিন learned advocate representing the contempt number 2 submits upon instruction that the district inspector of schools is yet to recommend the name of a teacher who may be a teacher as alternative arrangement to enable the authority to comply the direction passed by the court. কি দিয়ে শুরু করলাম? Yes, yet to recommend. ঠিক আছে. In view of the aforesaid submission, hearing of the contempt application stands at 13th November.
Lordship, I am appearing on behalf of the state
Yes.
contemptor DI Kujber.
All right. Why don't you find out an alternative arrangement and intimate?
We have issued notice for the same time also. It was fixed on 29th August as the last date, but no teacher came up, Lordship.
Oh,
We have informed this matter to SSC, Central School Service.
I do not know how it can be complied.
Twice we have issued notice.
Next.
Malada, there is a direction to submit the revoke.
My lord, I briefly appear on behalf of the petitioner.
Yes, please.
By the last order, my lord has been pleased to direct the alleged contender to file compliance report. Certificate of compliance.
Did you get a copy?
My lord, the order has not been complied.
Has not been complied. What was the order?
The order is page number 118 of the contempt application, my lord. 16 of the contempt application. The read petition against my lord, I am taking for Paid 116, my lord. Pursuant to the civil code decree, my lord, the read petitioner make a representation before the BLRO, my lord.
The authority was directed to take steps in accordance with the civil court's order.
My lord, to correct the record of right, my lord.
All right.
My lord, the record of right has not been corrected, my lord. Till date.
Where is the order of the civil court?
The order of the civil court
Page
is, my lord,
129 to 132 of the application.
it starts from the page 91. The ordering portion is page number 97, my lord. The suit will be the same, is decreed on contest against the defendant number 1 and ex parte order against the other defendant. Plaintiff to get the declaration of the right, title and interest in the suit property as described in the schedule of the plaint, with the further declaration that RS ROR and LR ROR are erroneous with respect to the suit property, my lord.
Yes.
Lord, my title over the property is undisputed, my lord.
Right.
The alleged contender and where the party before the civil court, my lord. They have contested.
Yes.
Your lordship, this pursuant to the round of litigations, the petitioner was given a hearing. Now the authorities have rejected the prayer, stating that the civil court hadn't had jurisdiction in dealing with LR ROR correction matters.
What right does that person have?
Your lordship, kindly, they have cited a category of judgments.
Yes.
The appeal was preferred by Zilla board.
Right.
But that was dismissed for default.
Right.
Thereafter, there is no appeal pending as of
then.
Now, the legal situation is that, as they has been advised also, but no appeal has been preferred as of now against this order.
You immediately make necessary corrections.
Your lordship kindly keeps it after the vacation so that appropriate legal steps may be taken by the authority.
An affidavit by the alleged contender has been filed in court. Stop. The same is taken on record. Stop. It appears that the necessary correction in the record of rights have not been made till date. Stop. On the prayer of the learned advocate representing the contender, hearing of the contempt application stands adjourned till 20th November. The correction of the record of the authority shall take strict steps in terms of the decree passed by the learned civil court.
And there will be a direction to correct the record of right manner.
Next.
May it please your lordship.
Yes.
Lord, I appear for the petitioner in this matter. A tender was awarded in my favor for construction of a G+7 university at HON'BLE, my lords. Subsequently, a year thereafter, the detailed project report of this university is changed completely from G+7, it comes down to G+2. I had made requisite arrangements arranged by men, material and machinery at the site for a G+7. Nonetheless, I try and continue the work. The drawings that are there for the G+2 not provided to me. 21, the project is awarded to me. Up till February 2025, the drawings are being contemplated internally. There are correspondences to that effect by the respondent authorities. Finally, on May 25, they call upon me saying, please collect the revised drawings. Well, thereafter, June 25, they issue a show cause notice, imposed penalty upon me. And July 25, the day I filed this writ petition, they terminate my contract altogether. Now, the instant petition, my lords, is necessitated in light of the fact that your lordships, after hearing this writ petition, had passed an order directing them to consider the case, because in any event, they'd had to appoint a third party to complete the balance work, my lords. Without doing that, what they have now today done is that they've gone ahead and issued a fresh tender. In light of these circumstances, my lords, I've approached your lordship. So if your lordship kindly has page first, your lordship's first.
Can the court compel the authority to continue with you for making the construction? Because this is your progress from 21 to 25. There has been no progress at all.
There has
Why
been
will-
progress, significant 10% progress in terms of the drawings. The drawings that they have given have progressed in terms thereof.
The authority is not happy with your progress. They intend to engage somebody else. What will the writ court do? Compel the authority to engage you?
My lord, I'll tell your lordship, my lords. August 24, they themselves tell me to put the project.
Where is the contempt, please say?
I'll tell your lordship.
Oh,
For-
is this a contempt or is this a regular application?
This is a can.
This is a can.
Requesting your lordship today to pass an order holding this fresh tender.
No, certainly
That's
not.
I'll tell your lordship, my lord. Your lordship, if your lordship kindly has a look at your lordship's order once, my lord.
Yes.
28th July this year, my lord will find at page 8
Yes.
of my
28th
lord's
July.
application, my lord.
Yes.
Here your lordships will have, my lords.
Authority can revisit the issue. If the petitioner is interested to proceed with the work, the authority can direct the petitioners to conclude the work. This
Para
was the
7 and
direction.
9. Yes, my lord.
This was the direction.
This is the direction wherein your lordship asked them to consider
Yes.
directing the petitioners to again restart the work and complete it in a time-bound manner. Without making any consideration to that effect, they have today gone ahead and issued a fresh tender notice, my lords. All that I'm saying is that my writ petition today will be rendered infructuous in the event this fresh tender is allowed to be proceeded with, my lords. And there is a judgment of the Supreme Court to the effect, the observation that fell down from your lordship, my lord, that in whether the writ courts can interfere in such contractual matters.
Yes.
When the facts are at large and these are crystallized facts, my lords, not disputed, then the writ court can enter into it, particularly in light of the fact.
No, the ratio of the judgment that you are referring, it doesn't apply in this case.
My lords, if your lordship will kindly have, my lords, HON'BLE consultants act a copy.
Adverse appraisal show cause notice. What is your submission?
Notice the work order was issued on 11 August 2021. Thereafter, my lord, issue the notice several times. 27 December 22, 23, 24 January 23, 27 to 23, 10 February 23, 17 August 23, 26 9 23.
Several opportunities granted.
Hereafter, my lord, the contractual is the untenable exclusions that is the season.
Please come.
May I, my lord? Your lordship will kindly
The
consider my judgment.
petition arises out of the disputes arising out of a contract. Step. According to the petitioner, because of the delay in providing the drawings, the petitioners could not proceed with the work,
and the
construction work, and the
non-payment of my dues not paid within contract.
the
Stipulated.
petitioner also alleges non-payment of the dues
Already paid.
for which construction could not proceed further. The authority has proceeded to terminate the contract of the petitioner.
Penalty imposed.
Stop. The petitioner prays for a direction upon the terminate the contract. The authority has also proceeded to issue fresh tender for selecting contractors to conclude the unfinished work.
Which is much more.
Stop. The petitioner submits that the delay in question was solely because of the respondents not providing the drawings in proper time. Stop. Also because of the non-payment of the dues, the petitioners were not in a position to proceed with the work. According to the authority, several opportunities were granted to the petitioners to conclude the work. Stop. Time period for conclusion of the work expired long back.
My lord, it's not expired yet. the time period.
26.
It's gonna expire in 2026
তাহলে এই লাইনটা
December.
কেটে দিন, লাইনটা কেটে দিয়ে লিখুন যে the manner in which the petitioners are progressing, comma, they will not be able to conclude the work even within the extended time period. Stuff. Upon hearing the submission made on behalf of the parties and on perusal of the documents placed before this court, it appears that the dispute between the parties arises out of a commercial contract. Stuff. There are several disputed questions of facts which cannot be adjudicated in the writ proceeding. Stuff. The petitioner may avail the appropriate remedy in accordance with law for redressal of their grievances. Stop. The writ court is not inclined to exercise jurisdiction in the matter. The writ petition fails. Connected application also stands dismissed. A report is taken on record.
Number 81, my lord. Item number 81, it will retain the same position in the list on the retainable date, my lord.
No.
It is only for the compliance.
Let us see. Next.
83, my lord, I am for the petitioner. My lord, on 21st of August, the matter was appeared before your lordship, my lord. What happened in this case, my lord? After filing the contempt application and during this period, the contempt member died. So there are two contenders. One is the DI of S.P. Mawla, another is my lord Director of Pension and Provident Fund, my lord. Both of them are detailed from the service. And I have added as per your lordship direction, I have added the new income also. And I have served the copy of the application upon my lord. But till date, my lord, I have not yet received the track.
Show me the affidavit of service.
My lord, affidavit of service has not been completed, my lord, but this is the letter here.
Show me that you have served.
Yes.
Where is the track report?
Track report not yet received, my lord.
When did you put it to post?
Yesterday, my lord.
Yesterday you put it to post?
Because my lord, I could not collect the names of the my lord contemnant.
Then how can they appear if you have?
No, my lord. I am seeking, my lord. Let the matter be adjourned for a week, my lord. In the meanwhile, I file my affidavit service, my lord. After obtaining the
there is no proof of service of the contempt application upon the alleged contemptors. Stop. Release the matter on 13th of November.
In the meantime,
service in the meantime.
How my affidavit service?
Next.
Page of the hop. I am for the contender, my lord. I have filed one.
My lord, I am for the petitioner, my lord. If your lordship kindly recollects this matter, wherein the tenanted, we are the tenants in the said shop rooms. We have vacated and handed over possession, and they have filed an undertaking that they will carry out construction. My instruction is till date no construction has been done as such. And so far the handing over of possession is concerned, they have filed an affidavit of undertaking wherein they have shown that they are going to hand over shop rooms to us. Now, if your lordship, they have, along with the said affidavit, they have also annexed a plan. As per the plan, lordship, what has happened is the shop rooms, dimension of the shop rooms has been minimized to the minimum extent.
Listen, that cannot be gone into in the
contract. No, I'm just bringing it to your lordship's kind attention. Lordship kindly sees it. Sees this chart.
It is there. It's already here.
Already sanction. As per the sanction.
Lordship, I will show to your lordship one.
Unnecessary.
Kindly sees this for a minute, lordship. This chart, lordship, kindly sees it for a minute.
1 minute.
And moreover, they have put on other shop owners who are carrying on business from whom he is collecting rent.
They were paying. Very unfortunate submission. I am readily willing to give handover the possession by after the monsoon is over. I have on the earlier occasion stated that.
Did you mention the time limit within which you hand over possession? When?
At the end of the April, I will hand over the shop room because the JCB I deployed could not work because of heavy rainfall, and the surrounding buildings are all.
Where have you mentioned? End of April 2026.
Yes, that is I have mentioned. Now kindly see paragraph 4.
And
it will take just 6 months. They have to wait for another 6 months. they will get the possession. But I have categorically submitted, as per the sanction plan, the shop room number has been located in the sanction plan I annexed. They will just have to wait for some time and they will get possession of that.
Or we are waiting for last 7 years.
And
That is another chapter.
and the fact that you are keeping somebody else in the said place, you have.
That is completely, my lord, on the footpath. Whoever is occupying is not relevant. Your lordship directed me.
Photographs were shown to me.
They are showing photographs on the footpath. If anybody put any stall, what can I do?
In the property
They are,
itself.
no.
And put by him.
Not at all, my lord. It is completely, my
Listen, you have come in later.
Later,
The petitioner was here, the court was here, and the person who represented your client was also there earlier. And the court knows what the fact says. You come in later and change your submission.
No.
Don't do that.
No, I am not.
You play your trick somewhere else, not here.
No, my lord. I have clearly stated
Please.
two things, my lord.
Only lordship, I was
come.
very humbly submitting to your lordship.
Lord,
Lordship,
he
kindly have a
has
look.
to wait only.
Lordship, kindly see the size of the room.
Wait only. What about the loss of income?
My lord, let me clarify.
No, don't clarify. The petitioner are losing income. That is their only source of income.
My lord, I have no source of income. It is my gifted property. It is gifted property by my mother. My brothers, 6 brothers gifted me. I am, my lord, a patient of the brain tumor. In spite of that, I am trying to hand over. Kindly consider my wife is also.
My lord, I had a shop room of 224 square feet. I have been given a shop room of 34 square feet. So kindly seize it once, lordship.
My lord, the corporation will clarify. As per the available sanction plan area, they have sanctioned.
Learned advocate representing the contemptor relies on the affidavit mentioning that the structure of the petitioner will be handed over by the end of April 2026. Stop. It appears that the contemptor is time and again giving undertaking before the court, but is not acting in accordance with the same. Stop. The court is taking a serious note of the conduct of the contemptor. Stop. Learned advocate for the petitioners have drawn attention of the court to the area of the shop rooms that will be provided and that the contemptors intend to provide to the petitioners after the construction is made. Stop. The area enjoyed by the petitioners in the old structure was far more than the one that will be provided to the petitioners after the construction. Construction is made. Stop. Paragraph. The petitioners are granted liberty to take up the said issue before the competent forum in accordance with law. Stop. The matter is made returnable in the returnable on the first Thursday of the month of May 2026.
Or in the meantime, my lord, some compensation may be awarded. Because on the last occasion, if your lordship kindly, appreciate, your lordship said, observe that if they don't do it within a certain time period, some compensation will be awarded to us.
Let us see. Call the next one, please.
185 for the petitioner.
Yes.
On the earlier occasion, they have prayed for time to take instruction, my learned friend.
The last occasion I only appeared first time.
Hmm.
On last occasion they have also not present.
Page 17 of the contempt application, third last paragraph. As it appears from the instruction provided by the engineers.
Yes.
As it appears
401 has been initiated. What happened?
My lord, here is my report. My lord, already order has been passed.
For regularization?
No, my lord, for demolition of the.
Demolition? Your authorities have this power to pass on demolition.
The order of.
Yeah, I always see regularization. I hardly see demolition.
My lord, that is that.
This is demolition. Give a copy to him.
My lord, I am giving.
8th of September 2025.
My lord.
Only because of the threat of
My
contempt.
lord, notice was given, PR was appeared at that point.
And November 22, the order was passed. Time limit was 12 weeks. They have forgotten calculation or what? And what is the where you put on notice?
No. No.
Necessary steps for compliance will be taken in due course. So you took more than 3 years to only pass an order. And how long will you take to implement it? Another 6 years.
No.
What no?
And the difficulty is, my lord, when the officer at that point of time that is changing constantly. So the previous officer who is actually
Please come. Learned advocate representing the contemptor. Has filed before this court a report signed by the engineers of the Kolkata Municipal Corporation, Building Department, Borough, VII, mentioning that steps were taken under section 400 within bracket 1 and 416 of the KMC Act 1980. And order of demolition has been passed on 8th September 2025. Stop. Necessary steps for compliance of the said order will be taken in due course. Stop. It appears that the said order has been passed allegedly in compliance of the direction passed by the court on 29th November 2022. Paragraph on 22 by which the court directed the authority to consider the objection filed by the petitioner alleging unauthorized construction and dispose of the same within a period of 12 weeks. না এই যে এখান থেকে একটু লিখুন তো কি বললাম তারিখের পর না 2022 এর পর ফুল স্টপ দিয়ে দিন ওটা কেটে দিন তো the court noticed that the corporation took steps under section 400 within bracket 1 and disposed of the writ petition by directing the authority to dispose of the steps taken under section 400 within bracket 1 at the earliest and latest within 12 weeks from the date of communication of the order. Stop. The order passed in the year 2022 appears to have been complied with in September 2025.
May I interrupt one, my lord, only? But the starting point, if your lordships actually kindly took my order, my lord, take my order, that is date of hearing 22, and that is the contemporary is Dipendupal who actually retired long back. So thereafter 23, thereafter 20.
And thereafter he has taken all the file away.
Only I am showing your lordships that.
No use showing.
Lordship.
He is the authority and this is the court.
Lordship, your lordship.
And there is nothing personal between that person and the court. Right? It appears that the authority did not take steps. The executive engineer was directed to take steps.
I am only saying that executive engineer retired 22 years.
And he retired and he took all the files away.
Year 2022, 3, 4, and 5.
3 years have gone in the meantime.
Your lordship is absolutely.
Then?
Your lordship is correct, my lord.
লিখুন তো কি বললাম Hmm. In September 2025, stop. The report filed today mentions that compliance of the order will be taken in due course. Stop. The petitioner is granted liberty to take steps for execution of the order in accordance with law, if so advised. Disposed. Next.
My lordship.
Yes.
I am for the petitioner, praying for not today.
Why?
We have not received a copy of the application also.
Let me see.
You know?
How are you appearing if you have not received copy?
Lordship, the matter is in the list, and Lordship, I have been instructed to appear because in the order sheet my name is appearing, but the contempt.
In which order sheet? In the writ petition order sheet. Contempt has not been served and you come in. Learned advocate for the petitioner seeks accommodation. Stop. Released on 13th of November. Service in the meantime. Next.
One 187, I am appearing, Lordship. Although I don't have a right to appear before your Lordship, but my humble submission before your Lordship is that
who are you?
I am the affected party in this contempt proceeding, Lordship.
My lord, I am for the contemptor, my lord, municipality.
Municipality?
Municipality.
I am for the petitioner, my lord.
Has the order been complied?
No, my lord. The order has not been complied. What they have done, they have filed an appeal, a misappeal from the order passed by the Board
Under
of
section
Administrators.
218.
আমি বলছি তো,
Yes.
From the Board of Administrators. Now, my lord, they are doing dilly-dally. Whatever they want, they are doing in the lower court. My lord, they have preferred and CO application before the coordinate bench. My lord, the CO has been disposed of by the Honorable Justice Hiranma.
Whoever, yes.
Yes. And my lord, only this month extension have been given to them for to dispose of the appeal. Only this thing, my lord. The scenario is this, and they have not complied. They are doing whatever they are like.
Kindly go through the order of the coordinate bench, Lordship.
Sorry, sir. I am not going
Kindly go through. Kindly revisional court, Lordship, has passed an order to dispose of the revisional application within
It
1 month,
has
Lordship.
been brought to the notice of the court that the order passed by the Board of Councillors has been. Administrator is there. Which municipality?
Kotrang municipality.
Uttarpara Kotrang municipality, my lord. Order has been complied.
There is an administrator.
At that time, my lord, there was an administrator, my lord, due to election procedure.
Oh, Board of Administrators. Board of Administrators have been taken up in appeal, which is still pending. Stop. Paragraph. As the order of demolition is already pending consideration before the statutory forum. Accordingly, no order can be passed in the contempt application. Stop. The contempt application stands disposed of. Stop. It will be open for the petitioner to take necessary steps in the matter after disposal of the statutory appeal by the competent forum. Yes, next.
petitioner, Lordship will remember that this matter is with the order dated 9th of July 2024. Your Lordship has given the observation that the petitioner wants compounding of the offences. Lordship knows better than me that compounding of offences can only be done by the complainant. Here, I am the accused. I was arraigned as an accused. It was a civil proceeding was going on in the court of in the Shialda court, where advocates started verbally abusing me. When I protested, I was illegally detained by the police
Petitioner
officers
was
there.
client of the
I was assaulted and I was illegally detained there. My prayer was for quashing of the offences and to declare the arrest illegal and for some compensation and all. Now, Lordship, without following the guidelines of Anish Kumar, I was
a
arrested.
charge sheet has been filed.
Yes, Lordship,
Then-
charge sheet has been filed now. Charge for framing of charges. The date was before the learned court below in the month of August, which due to some circumstances it didn't happen. Now the date is in the month of November.
Yes.
Lordship, if Lordship doesn't go into the merits and doesn't quash this malefied proceeding, I will be charged there. I have to face the trial, and my rights are being violated. My fundamental rights are being violated.
What is your fundamental right that is being violated?
Milord, I was illegally arrested. These proceedings are malefied and vexatious.
No, but then the learned trial court will take note of it.
Milord, I have no other option there. I cannot opt for discharge also at this point of time.
Yes. Yes.
I have to directly face trial. And also, Lordship, Bhajanlal states that under Article 226, Lordship has the power to quash the proceedings. When I have that remedy, so, Milord, I...
You are Shobhik Ghosh.
Yes, Lordship.
Are you the advocate or the client?
I'm the client.
You are the client.
Yes, Lordship.
Yes. And where is the respondent number 6? Did you serve this application?
Yes, Lordship. We have served the application, and on the last occasion they appeared also.
They appeared?
Yes, Lordship.
Where? I do not see their appearance in the application. In the writ petition they appeared. Where is your service upon the, is your affidavit of service there?
Yes, Lordship, I have the affidavit of service with me. Lordship, this is the affidavit of service.
When did you serve?
Lordship,
long back.
Yes, Lordship.
Give a notice. Please come. None represents the private respondent. Let fresh notice be served upon the learned advocate representing the private respondent. 6th November. Service is taken on record.
Right.
Much obliged, Lordship.
My lord, I appear on behalf of the petitioner. My lord, the order dated 26/6/2023 has not yet been complied.
But we have completed the demolition.
Completed?
Completed. Single-storied building, demolition completed. I am not with the compliance report. Now, my lord may send a special officer. They will, because their building is also going to be demolished.
Yes.
Well, let it be. I am not, I'm only placing this because single-storied building, we have done everything. And I will come with a compliance report with an affidavit. Thereafter, my lord may appoint a special officer.
Why are you not coming up with photographs?
I have got the photographs also.
You have? Yes. Let me see.
All the photographs are not there because last date Serious demolition has also been conducted just a few days before, for 2 days.
The structure has been rendered uninhabitable. But then,
Single-storied building.
single-storied building. The walls are there.
Everything has thereafter everything has been.
Everything has.
In any manner, I will come with a compliance report. That will be.
25th August, the walls are there.
I will come
It's
with.
come.
And thereafter, I will appoint a special officer. Then he will.
Thereafter is different. Learned advocate for the petitioner submits that the demolition work has not been completed till date. Stop. Learned advocate representing the contender relies upon the report of the engineers of the corporation dated 10th September 2025 along with photograph dated 25th August 2025 in support of the submission that a substantial demolition has taken place. Stop. The parties are directed to revert with photographs on 6th of November. Next.
Photographs and I will file an affidavit.
Next.
My lord, kindly see, my lord, your lord.
Demolition has been done completely. And I am placing the report.
My lord, kindly see, my lord, he is not properly instructed. Here is my photograph.
Date of the photograph.
Your lordship directed.
Date of the photograph.
My lord, 20th August. No, my lord. September. It should be there.
20th August it would be, but I have given the report on 4th September.
Yes.
4th of September.
Yes,
and my lord, I have.
This is the photograph of the 3rd September. 3rd September. Now, your lordship direction was demolish the outer wall.
Yes.
Your lordship kindly see.
Yes, we already 1 minute. They demolished the total roof, unauthorized second floor, including 90% parapet wall on that roof. Now, after demolition, they were denying to work as the building is adjoining other to severe injury, life risk may happen.
There is deviation in G+.
Yes, however, this office is undertaken further, so we are requesting with the help of structural engineers, panel must be informed the current situation.
Now, your lordship kindly see your lordship last order.
And what is the dangerous condition is that, my lord, that is that if your lordship sees that second floor which has been.
Now, my lord, kindly see.
1 minute. Is the entire structure unauthorized?
No. G+1 is deviation. And G+2, that extra floor, that has been 90% demolished.
Alright.
And
demolished.
Yes.
My lord, kindly see your lordship last order.
No, after one. And G+1.
Your photograph shows that it has been demolished. Roof and the sidewalls.
Direction was.
They want that deviation should also be demolished immediately. Only some time is required. Deviation we will do.
Against that order, my lord,
deviation we will do.
Has preferred appeal.
Went before the appeal court.
Yes.
Now, my lord, kindly see the appeal court.
Your
lordship's order confirm and with some observation. Kindly see. No demolition of the outer walls, my lord. No demolition of outer walls.
Peruse the photograph.
Absolutely false submission.
Peruse the photograph of the
Special officer may be
subject structure, subject unauthorized structure. Dated 3rd September 2025. It appears therefrom that the roof of the second floor has been demolished substantially. Stop. The side walls are, however, remaining.
Yes.
ঠিক আছে? The
Your Lordship,
assistant engineer of Borough 2 Howrah Municipal Corporation has forwarded a report mentioning that the contractor entrusted for demolition of the unauthorized construction
একটা রিপোর্টের কপি দিন
is not able to take the responsibility of further demolition
রিপোর্ট ডেটটা কম লিখবে তো এগুলো
as there are buildings adjoining and a severe injury including life risk may happen anytime during demolition. May happen anytime during demolition. Stop. Next. As the construction in question is admittedly an unauthorized one, the corporation shall certainly take steps to demolish the same as indicated by the order dated 6th August 2025 passed by the Honorable Division Bench in MAT 689 of 2025 with Can 1 and Can 2 of 2025. Within bracket Soumitra Ghoshal and another versus the State of West Bengal and others. Stop. The matter is made returnable on 6th November 2025.
Some time to be given because we have to take some instructions from the
4th of December 2025. Further report shall be placed before the court on the adjourned date.
Hello, private respondent went an appeal. Your Lordship.
Obviously, his structure is being demolished. He will go in appeal.
And your Lordship's order, my lord.
Yes.
My lord, photograph may be kept.
Yes, photographs are taken on record.
And for the petitioner, my lord.
Yes.
Pursuant to your Lordship's direction, my lord, an order has been passed by the SDO. My lord, the SDO, my lord, has completely shut off his responsibility to, my lord, comply with your Lordship's order.
My application for recalling is on my mentioning the matter has come.
All right.
Kindly, my lord, see the order of your Lordship.
Mm-hmm.
I have an application, my lord, for recalling. I went up to appeal court, my lord, since I could not appear because my learned advocate, my lord, who was suffering from deadly disease, ultimately died. So he could not come to court for some time, and therefore, my lord, ultimately I got unrepresented before your Lordship. I went up to appeal court, my lord. Kindly come to the appeal court's order in my CAN application 1 in connection with WPA 16732 of 2023.
Can 2?
Can 1.
Can 1. What is Can 2? 340.
Huh? In 1 of WPA 16732 of 2023.
Yes, Can 1.
Kindly come to the order of the appeal court first ballot, page 78, for which I have been granted liberty to approach your Lordship's court.
Yes. Yes.
Malad, this was an order, the judgment and order it is whereby the...
Yes, I have seen.
By the order impugning the learned judge directly.
Yes, I have seen that.
There was no order of demolition at all.
There was no order of...
No order of demolition. An order has been procured from your Lordship by not, my lord, disclosing the actual fact, and your Lordship directed demolition of the said building. Kindly, my lord, come.
The order was passed by the Pradhan of the Gram Panchayat.
No Panchayat order is there. Kindly look at the order. I have, in the writ petition itself, it is annexed. Panchayat did not pass such an order. Let my learned friend show your Lordship where the Panchayat has passed. 117.
Yes.
This is the order, my lord. Kindly come to, my lord, the Honorable Justice Tapobrata Chakraborty directed the Panchayat to take a decision regarding demolition. Kindly, may I place it? মহামান্য হাইকোর্টের তারিখে বিচারপতি তপব্রত চক্রবর্তী মহাশয়ের অর্ডারের পরিপ্রেক্ষিতে 7/11/22 বেলা 12টায় সরিষা গ্রাম পঞ্চায়েত অফিসে অজয় কুমার ভান্ডারী পিতা সোয়াংশো সভা অনুষ্ঠিত হয়। Leave aside, my lord, today at that last paragraph in the said page, today the first party at 12 noon on behalf of the first party, Pradeep Tarokdar, so, my lord, may I skip to the second page? The father of Mrinmoy Bhandari, second party, file an application for building plan of 2-storied building. The previous Pradhan on 15/8/2015 approved the said building plan up to the first floor instead of the second and third floor. It was also informed to them the owner Ajay Bhandari on 18/1/2009. Pradhan informed the
Page 118, it was referred to the SDO.
SDO.
Yes.
It is referred to the SDO.
Yes.
Here the SDO order is not the issue before your lordship, the writ court. This order is not the SDO's order. SDO's order
There is an order of demolition forwarded to the SDO, whether the
no order of demolition. What is the finding of demolition? He has said that allegation is
finding of unauthorized construction.
Yes, referred to SDO. SDO has referred it to the Jila Parishad. SDO also did not pass any order. Referred it to the Jila Parishad that this is Jila Parishad domain.
All right.
No demolition order has been passed by Jila Parishad as yet. The question of demolition does not arise, my lord, because the order has not been passed by any authority.
Yes.
And you,
My lord,
and your lordship order on 3rd October.
3rd of October.
Yes, kindly see the last paragraph of the first page.
Yes.
As the Pradhan has already forwarded the documents in connection with the order of demolition, subdivisional officer is directed to take necessary steps for implementing the same in accordance with law. Therefore, proceedings under 23(5) was directed to be initiated.
Pradhan has not referred the demolition order. He said, I have no jurisdiction. 3rd floor, I have no jurisdiction. I am sending it to the SDO.
Unauthorized construction has been detected.
I have a two floor sanction. 3rd floor, I have no sanction. There is certain construction that has been stopped by the Panchayat. No construction is being carried out.
Yes.
This is not. There is no 3/4 building. The 2nd and 3rd floor. Up to 2nd floor, my lord, is a sanction plan I have got. So far as the 3rd, I am to state it to the authority. That hearing is still pending before the Jila Parishad. Jila Parishad has not issued the matter any order. Pradhan has no power of passing any order of demolition.
Page 117 records that the 2nd and 3rd floor constructed without any sanction.
Exactly.
3rd floor is not there. That is exactly what we will be
Gram
canvassing.
Panchayat never sanctioned any 2nd and 3rd floor.
Yes.
This is what is recorded in the order.
No sanction in the 2nd and 3rd floor. I am not constructed 3rd floor, demolished 3rd floor. I have a 2nd floor sanction plan.
It is recorded the Panchayat has not issued the sanction.
But Panchayat has referred it to the SDO. Let it be hearing. Let there be a hearing before the SDO.
See page
Show me
100.
your sanction.
Well, there will not be. Kindly see page 110 of the writ petition. Their submission is recorded. Kindly see page 110 of the.
Show me your sanction.
I have a ground floor and first floor. Ektala, dotala sanctioned. I have a sanction plan for that. Now she keep it on the next day. I shall bring the sanction plan.
Entire issue is 2nd and 3rd.
2nd floor is no 2nd floor is there. No 3rd floor is also there.
Very well. In that case, let whatever is there in the 2nd and 3rd floor be demolished.
Let the order be passed. Demolition order. Who has passed the order? Lordship has directed implement the
Let
Panchayat
it be
order.
passed. Where is the difficulty?
I have no problem in this, but Lordship directed that as the Panchayat's order is a demolition order and you implement it.
No,
How the Panchayat's order can be implemented by SDO?
My lord has
Because SDO has referred it to the
23(5).
that has been referred to the Jila Parishad, SDO himself.
May I indicate that? Below D 160A subsection C mandates that in case of unauthorized construction, if alleged, the hearing has to be by the hearing officer. It is this reason that the SDO has said, in terms of this, I do not have the jurisdiction.
No, but then this is an amendment.
This is,
It came
Throughout
when?
West Bengal, no hearing officer has.
There is.
I will come to that.
I am aware of it.
I'll come to this. I'll come to this. Lord, I am to assist your lordship exactly on that. Lord, throughout West Bengal, I do not know. Lord, we have advertised for the hearing officer. Zilla Parishad has duly advertised for the Zilla Parishad in respect of this hearing officer. Lord, on the first Lord, advertisement, no suitable candidate was found. Lord, we have got. There is a second advertisement, and now we have got good candidates. Lord, we'll be appointing immediately with whatever time 4 weeks, 6 weeks, your lordship gives us the hearing. Lord, my humble understanding, Lord, the Pradhan, the hearing officer will have jurisdiction, not the SDO, neither the Pradhan. So hearing officer
Came in later on. That time it was the SDO only.
This is the SDO's order in this matter.
SDO was there.
SDO referred it to the
Possibly.
Jila Parishad.
When did the hearing officer come in this provision?
2017, possibly. It is.
It was there. All right.
So, my lord, I was humbly praying, my lord.
Yes.
We will hear out the matter. My lord will kindly give us some time to come back with a happy face that yes, we have appointed the hearing officer and he will conclude immediately. For the timing, my lord, your lordship, subject to my lord, what falls from your lordship, kindly allow us.
No, the court didn't pass any order of demolition. So the whatever
hearing officer has to be today, my lord.
The court has directed execution of the order of the Panchayat.
Yes.
Excellent.
Yes.
Milord, first, Milord, let me deal with Mr. Bhattacharya's submission, then I'll come to Mr. Chatterjee's
No,
submission.
I'm not opposing
No,
this.
his submission, he has not made any second and third floor.
Yes, I'll come to that. Milord, kindly see, Milord, page 110 of the Milord writ petition.
Second floor the sanction ache.
Milord, writ petition was not disposed of in absence of the writ petition.
What?
This is the
First
first incorrect submission.
Ground floor, first floor sanctioned.
This is the first
Second floor
incorrect
construction
submission.
stayed by the Panchayat. No construction is being done.
That means you made construction.
Yes, yes.
Wanted to do it. Let that portion be demolished by the Panchayat, no problem. But Panchayat should initiate a proceeding for that.
Yes.
Panchayat has said, I have no jurisdiction.
Kindly see page
SDO has
1110. Kindly see, Milord, the last paragraph of page 1110, and this was my learned friend said, Milord, they were not represented. Milord, kindly see, respondent number 7 was duly represented by a learned advocate. Only because that learned advocate is no more in this world, Milord, allegation has been made. Now, Milord, kindly see, Mr. Mondo, learned advocate appearing for the respondent number 7, disputes the contention of the petitioner and submits the construction up to the first floor level is complete on the basis of the sanction plan. As regards further construction beyond the first floor, the respondent number 7 has already submitted an application.
That is before Justice Dapapati Chakraborty, not before your lordship.
And Panchayat, Milord, kindly lordship has seen the findings of the Panchayat. They have not. Now, Milord, regarding Mr. Chatterjee's submission, kindly comes to page 94 of the writ petition.
Yes. 94.
Yes. Kindly comes to page 94. Kindly see, Milord, this is the record of rights.
Yes.
Kindly see, Milord, last but one, dag number 244.
Yes.
This is Shali. And Milord, kindly see name on the right hand side, Ajay Kumar Bhandari. He is the private respondent. Therefore, Shali. Now, Milord, my point is, I argued before this SDO. Why you do not have? You certainly have. Because if it is a Shali, lordship knows under Rule 27, no plan can be given even for the first floor itself. If Milord, first floor, Milord, is illegal, Panchayat and the SDO has jurisdiction to decide so.
That has already been, conversion has been done.
Said so. Go before
conversion done. Kindly look at the order of SDO lastly passed in terms of your lordship's order. This is the order of SDO.
244. Still, Milord.
This is the certified copy of the order of SDO. Referring it to the Jila Parishad to take a decision.
Therefore, Milord,
affidavit of
Pradhan and
compliance.
SDO are still jurisdiction up to ground floor.
Affidavit of compliance filed in court today by the subdivisional officer, Diamond Harbour.
শুনুক না শুনতে আমরা চাইছি
Filed in court is taken on record.
শুনে তো অর্ডার পাস করেছে এসডিও
Stop. It appears that
এসডিও তো অর্ডার পাস করে দিয়েছে আমার জুরিসডিকশন এটা অর্ডার চ্যালেঞ্জ করো
the subdivisional officer has submitted that he does not have any authority to pass an order of demolition. Stop. The learned advocate submits that hearing officers that at present there is no hearing officer for conducting hearing, but steps are being taken for appointment of hearing officers. Stop. Some time has been sought for to comply the direction passed by the court. Paragraph. Learned advocate for the petitioner asserts that construction has been made over agricultural plot of land, and the Pradhan and the subdivisional officer does have the determination to decide the issue of unauthorized construction.
Well, the conversion has been done. Kindly record my submission.
Stop. According to the private respondent, order of conversion has been passed, and it is only thereafter that plan was sanctioned. Stop. Paragraph.
This is, let them clarify.
Date.
Date.
Anyway, as time has been sought for conducting hearing by the hearing officer, the contempt application stands adjourned till 11th December 2025.
So very grateful.
The an updated report by the contemner shall be placed before this court on the adjourned date. Stop. It is expected that hearing officer will be appointed in the meantime.
Absolutely.
Who will decide the issue prior to the adjourned date.
Absolutely.
Milord has been filed. Milord, this is an application for 340. Milord,
Yes.
Kindly ask them, Milord, if they want to press this, Milord, then Milord, I have instructions to Milord, lodge a complaint for the bar against the advocate on record. If they want to press, can too.
Which if they want to press, it is your application.
No. Can too is, I have not filed any. I have filed only contempt.
We filed an application under 340
They want to say,
Yes.
Milord, I have
for
specific
making the false
instruction,
affidavit. For the, you are not pressing it now, my lord. Lordship, all the matters stand adjourned till that date.
Milord,
We are
if they
not
want
pressing
to
that.
press, Milord, I have instructions to Milord go
We
to
are
the
not pressing, brother.
In that case,
Withdraw it.
I'll dispose it off.
Withdraw it.
340?
Yes.
Lordship, dispose it off.
Achha. The application can too has been filed by the private respondent. Stop. The learned advocate representing the applicant submits that his client does not intend to proceed with the said application. Stop. In view of such submission, can too stands dismissed as withdrawn.
Obliged.
Yes.
Evidence service be kept on record. I have sub.
Not press করে দিন, not press করে দিন.
Not pressed. Evidence of service টা রেখে দিন.
Hearing officer is appointed, he will give us a notice, Milord, to parties and kindly, Milord.
Hearing officer যেখানে বললাম hearing upon notice to all the parties. Yes.
My lord, I did appear for the petitioner, my lord.
Yes.
Contempt, my lord. The order, the appeal has been prepared by the private respondent. The stay, other day also submitted the stay. The stay has been granted by the appeal court, my lord, till 24th October 2025.
Show me the order, please. Where is the order?
Oh, that is what I sent you from the moment.
Give the number, please, and the date.
But appeal there because the trial court.
Oh, trial.
Demolition order, against the demolition.
Oh, demolition order.
Yeah.
All right.
All
right, I got it.
As the order of demolition, they are challenged.
All right, please come.
But that is misappeal law 1 of 2025.
All right. The order of demolition passed by the municipality has been challenged by the person responsible for making unauthorized construction before the competent forum.
Learned Court, Civil Judge, Junior Division, Sub Court, Katwa.
The said appeal is pending disposal.
Yes.
Stop. Next. In view of the above, the contempt application cannot be proceeded with at this stage. Stop. The contempt application stands disposed of. Stop. It will be open for the petitioners to take necessary steps in the matter after disposal of the statutory appeal. Next.
My lord, in this matter, my lord, I am for the petitioner, my lord.
I am for
My lord,
the
your
respondent
lordship
contempt.
kindly see your lordship's order dated 24th of July 2025, my lord. This is the last order, my lord, passed by your lordships, my lord. Your lordships kindly see the order. My lord, till today, nothing has been done.
Nothing has been. Now I am
Yes,
placing the report.
Let me see. Let me see the report.
My lord, your lordship kindly
This
see
is the
the
report.
photograph,
This
my
is
lord.
we have carried on demo. আগে আমাদের শেষ করে দিন, আপনি বললেন।
I am the petitioner. I will-
Photograph,
I
listen,
will
listen,
ask
listen,
them.
listen,
Yes,
listen. Show me the photographs.
Yes, my lord. Your
Yes.
lordship kindly see. You are the contemptor?
I have to face the contempt. Why shall I sit?
Do not behave.
Why shall I
He is
sit?
your learned friend.
My lord,
He is your friend.
to make my submission.
I can hear you, sir. Don't get agitated.
That is it.
Your lordship kindly see.
Let me say that what happened.
Ah.
On 8th, we have went for demolition. 2 days demolition has been done, but problem is this: the occupants are not vacating it. And my lord, later direction will be given that specific direction that the occupants may be vacated in the meantime. We will finally complete it. We have no intention.
What is the unauthorized construction?
Second and third floor, my lord.
Second and third floor.
Two extra floors.
I have
the
marked it.
occupants are. We have done the demolition. That not that.
Not.
But fact is this: let them then vacate it. Let them vacate.
Please come.
My lord.
Learned advocate for the petitioner submits that the unauthorized construction has not been demolished till date. Photographs in support of the said submission has been placed before the court. Stop. The same is taken on record. Please give. Learned advocate representing the contemptor submits that steps for demolition of the unauthorized construction was taken. Stop. The demolition squad continued the demolition on 8th September 2025 onwards. But as the occupants refused to vacate the structure, the structure entire demolition could not take place. Stuff next. Some time has been sought for to conclude the balance demolition work. Stuff. As the construction in question is unauthorized, the demolition of the balance construction work has to be conducted by the corporation without any further delay. Stop. Hearing of the contempt application stands adjourned till 11th December 2025. Stop. Further updated report shall be placed before this court on the adjourned date. Stop. The Commissioner of Police, Howrah Police Commissionerate, is directed to render adequate assistance to the men and agents of the Howrah Municipal Corporation for vacating the unauthorized structure. Stop. The police would be entitled to use reasonable force for removing the occupants. Stop. The occupants are restrained from interfering with the work of demolition.
Yes. Kindly specify the date, time.
I have.
The commissioner of police will not vacate. For the police authority.
Next.
Photograph equipment.
Photographs of the building
is on record. It is on record.
I'm for the petitioner.
Yes.
So I'm for the private response.
Yes. Jila Parishad.
Municipality.
Municipality. Yes.
My lord, your lordship on the last occasion, my lord, on 24th July, my lord, passed an order. But that order was challenged by my learned friend, though he is not a party to the contempt proceeding here. There is no private respondent here, I suppose. And my lord,
In the writ petition, was there a private respondent?
he was there.
Oh.
Lord, he challenged the order, my lord, in appeal, in mandamus appeal, my lord, an order has been passed by the Honorable Division Bench,
Mandamus
my lord.
appeal, I see it was a statutory appeal.
Statutory appeal he made.
Then?
But that in that appeal, my lord, he succeeded, and the order of demolition of the municipality was set aside. Then, my lord, it was placed before your lordship. After going through that, my lord, your lordship passed an order that still the construction remains. That's why your lordship directed the municipality to take steps. My lord, that order of your lordship was challenged in appeal to the Honorable Division Bench, my lord, and the Division Bench, my lord, had passed an order.
Setting aside this. All right. Please come.
Contempt application
the order of
The order dated 13th August 2025. Passed by the Honorable Division Bench in Mat 12/17 of 2025 with IA number CAN 1 of 2025 has been placed before this court. Stop. The
page 4, paragraph 50.
Paragraph 13, 14, 15.
On a perusal of the said order, the court is of the opinion that the contempt application cannot be permitted to proceed further. The same stands disposed of. Yes. Next.
Get.
One 196, I'm led by Mr. Chitrapriya Ghosh. There is an new incumbent, contender number 1. Give a liberty to add him and serve afresh. As served as per last direction, so the service.
Affidavit of service filed in court is taken on record. Stop. Leave is granted to the advocate on record of the petitioner to implead the new incumbent as party contender in the instant writ petition, in the instant contempt application. Stop. Let copy of the contempt application be served upon the new incumbent. Stop. The present incumbent shall be obliged to comply the order passed by the court. Contempt application is made returnable on 20th November. Affidavit of compliance shall be filed on the adjourned date.
Grateful, my
This matter, madam, I am appearing for the contempt. This is affidavit of service, my lord. Your lordship directed, my lord.
Yes.
Your lordship's order, my lord, pays, my lord. Your lordship's order pays, my lord, pays, my lord, 26.
10th October 23?
Yes, my lord. 10th.
Yes.
My lord. After passing the order, it was communicated, my lord.
Yes.
They have not paid, my lord. They have
EPU. Yes.
Lord, I have some objection.
Yes.
Now, my lord, kindly come to page 29.
Yes.
I think, my lord, this was the first and last communication, that is 11th October 2023. Has my lord got it? Then, my lord, kindly skip over to page 18. 18. My lord, paragraph 8.
Yes.
And now, my lord, who is the petitioner in this contempt application? Vishwajit Hajra.
Yes.
Son of the petitioner, that is deceased Sikha Hajra.
Yes.
This Vishwajit Hajra was never, my lord, substituted.
Where will he be substituted?
Well, he ought to have made an application before the disposal petition.
Where to make the application?
Before the authority concerned, stating details, giving his identity, his entitlement. We do not know. And now, my lord, who has affirmed the affidavit? Not even that Vishwajit Hajra. It has been affirmed by his father.
By his father? That means the husband of the deceased?
Yes. And no authorization even is there, I find at least, from my copy. Son is authorized, son and father, my lord. There is no formal authority, my lord.
No, you are the son.
Yes, I am the son, my lord.
The husband also has a claim. You have not made the husband a party.
Yes, my lord. But son is... It would have been fair enough. Had there any application been filed
Please come.
by the petitioner before the
The
authority?
petitioner alleges non-compliance of the direction passed by the court on 10th October 2023. Stop. By the said order, the court directed the Murshidabad municipality to disburse the terminal benefit of the petitioner Shikha Hajra. Read petitioner likhun. Shikha Hajra. Stop. The contempt application has been filed by one Vishwajit Hajra, claiming to be the son of Shikha Hajra, who has expired. Who expired on 7th February 2024. Stop. The fact of expiry of the employee was never made known to the municipality. Stop. The contempt application, though filed by the son of the deceased employee, but the same has been affirmed by his father. That means, that is, the husband of the deceased employee. Stop. The petitioner ought to have drawn the attention of the municipality about the death of the employee. Stop. Paragraph. The court is of the opinion that the contempt application will not be maintainable, as there has not been any deliberate, intentional or willful violation of the order passed by the court. Stop. The heirs of the deceased writ petitioner may approach the municipality for repayment, for payment of the legal dues of the employee. Contempt.
In terms of the order, your lordship mentioned.
You go. Then in
To make application afresh.
1 year already passed, they have not taken step. Order was passed, my lord, 10/10/2023.
Next matter.
My lord, I am appealing on behalf of the alleged contender.
Yes.
On behalf of the
fund in respect of.
my lord, am I audible?
The municipality has requested the director to release the fund. I am filing the affidavit of complaint. Enter gratuity has been paid.
Audible, my lord.
Yes, petitioner.
There are 4.
For the petitioner.
They have paid the.
My lord, am I audible?
Yes.
My lord, am I audible?
I can hear you, sir.
Mr. Madam.
My lord, not entirety has not been paid. My lord, I will humbly beseech your lordship to take up this matter next Thursday. But I want to do this physically. 198 to 210, my lord.
198 to 210, please record an order. Affidavit of compliance filed in court is taken on record. Stop. Learned advocate representing the contemptor submits that
Para 6, enter gratuity has been paid, my
that
lord.
the gratuity amount of the petitioner has been paid.
In respect of area pension.
Stop.
Page 4, municipality requested the director of local bodies.
The area pension, however, could not be paid as the municipality is in fund crunch.
Yes.
Stop. Some time has been sought for.
Yes.
Paragraph. The municipality, now as the petitioner is the.
Well, petitioners are employees, my lord, of the Purulia municipality.
Are employees, retired employees of the municipality, the municipality would be bound to pay the retiral dues. Stop. Hearing of the contempt application stands adjourned till 11th December 2025. Stop. It will be open for the municipality to arrange for funds for releasing the terminal dues of the petitioner.
My lord, direction may be given to the director of local bodies.
No, you are for the municipality.
Claim for area pension on 8th April, my lord.
You forward it and you take it up with the director of local bodies.
Great.
One by one it will be called so that the Jana Babu, apni ki affidavit of We'll call one by one so that it can be taken on record, one by one. 199 affidavit of compliance.
198, 199.
Have you given all?
Yes.
Please put it in the file. Yes, call the next matter. 211. Is anybody there? 211. Dismiss for default. 200 and 205. Are you there? No. 200. 200. All right, give 200. 200, you are appearing for whom? Hey, 200. 200, you are appearing for whom? 205 for whom? State, this is a contempt matter and the municipality is the contemptor. Are you there? There may be in the writ petition. Writ has been disposed. Are the other parties? Are they parties?
Contempt application is the municipality.
Yes. Call, please.
112 lawsuit, I am appearing the petitioner.
Yes.
And passed an order on 22nd August 2024, directing to serve the copy of the contempt application that was also served lawsuit that was also received. Service lawsuit. Initial order lawsuit was directed to the Pradhan to consider my representation whether the
Not complied.
No step was taken.
Is the Pradhan still there?
Yes, yes.
There is a rule. None appears on behalf of the contemptor. Affidavit of service is taken on record. Let contempt rule be issued, returnable on 6th November. Requisites to be put in at once. Next.
Contempt petition টা দিয়ে and 239 I am for the petition.
Yes.
This is the affidavit of service. Please kindly come to your lordship's order dated. Is at page 22.
What happened?
24 is the operative part.
Huh?
They have passed an order.
Yes.
This is the order.
For contempt goes.
So kindly see your lordship's order and the order they have passed.
Whatever is the order, you have to challenge it.
No, they have said so. You will kindly see the order.
Yes.
Last part. They have admitted that there is an unauthorized construction and directed to demolish the same.
Yes.
And your lordship order was specific. Like if any unauthorized construction, then necessary steps shall be taken to deal with the same in accordance with law. The entire exercise shall be conducted at the end, earliest but possibly within a
Take it
period
up in a fresh
12 weeks.
petition. Please come.
12
The
weeks.
order passed by the Commissioner, Asansol Municipal Corporation on 18th November 2024 is placed on record. Stop. It appears that the corporation detected unauthorized construction and directed demolition of the same. Stop. The time period for demolition has also expired. Stop. It will be open for the petitioner to pursue remedy before the competent forum for executing the order of demolition. Contempt application stands disposed of.
As well.
Next. Service ki aaj ke dilo? Service is taken on record.
I have filed the affidavit.
Lord, I beg to appear on behalf of the petitioner, Your Lordship. Lord, kindly take up the pen to come to page 13. That is your Lordship's order, and page 14 is the operative portion of the order. Lord, page 14, third paragraph. Third and fourth copy.
Yes.
Direction file. Page 14.
Direction file.
Whether
You
is
have
the
not
first step.
Yes. What happened thereafter?
Lord, we have served notice upon them. That is the next annexure. Annexure P2.
Thereafter, nothing happened.
Nothing happened.
Unauthorized construction was detected.
Detected.
Yes.
Lordship, I'll come up with the instruction, Your Lordship. A week's time, Your Lordship.
The corporation, too. But contempt, there is a, I'm not wrong, there is a private respondent, if I'm not.
Please come.
Lord, let me check. Lord, let me check for.
The petitioner alleges non-compliance of the direction passed by the court. Staff, learned advocate representing the official contemners seeks time to revert with instruction. Staff, let an affidavit of compliance be prepared
Illegal construction
and circulated prior to the adjourned date. Released on 13th of November.
Serve notice, Lord, in the meanwhile.
13th of November, you have served. Did you not serve notice? There was a direction for service?
It has changed with Lord. I have to see.
Exactly, I can remember possibly a copy.
Yes. Notice has been served. I have that affidavit of service.
Right.
Yes, it has changed. I'm grateful, Lord.
13 November, you see, 13 November.
13th of November.
For report.
Next.
My lord, I am for the petitioner, my lord. My lord, on the earlier occasion, your lordship directed to serve upon the respondents, my lord. Contemners, my lord, I have served, my lord. This is my affidavit of service.
Who is the contemner?
Lordship, I'm for
My lord, the Pradhan of.
Here also, I'm just praying for a week's time.
My lord, your lordship passed the order on 3rd of October 2023. Till date, no hearing has been given and no order has been passed with regard to unauthorized construction at the instance of the Pradhan.
Copy has been served.
I'm the affidavit of service.
Are you there for the Pradhan?
I'm for the Kolkata Municipal. I'm Rehanadi.
No, এটা তো পূর্ব মেদিনীপুরে না।
This is the
My lord, I'm referring in wrong.
right. This is for the Pradhan. None appears on behalf of the contemner. Rule issue করলাম না আগেরটা? Same. Yes, same date.
Grateful.
Rule is issued.
The procedure lordship direction, this is the evidence service. The Pradhan in the contempt has received the copy.
Nobody is there.
No steps, nothing.
Rule issued. Issue rule. It is returnable in the first Thursday after reopening, 6th of November. Yes.
My lord, I am for the petition. My lord, this is the affidavit of service. My lord, copy has gone.
Contemner, I'm led by Mr. Shamal Kumar Das. In this matter, Lordship, there is one criminal revision pending, and that is why the Lordship order cannot be complied.
Is there any stay by the court?
Yes, it has been mentioned there. I cannot produce right now, Lordship.
What is the number? Are you aware of any such criminal revision?
No, my lord. On last occasion, it was not mentioned.
What was the order?
Order was passed against
For removing Gumti.
Yes, my lord. Removing Gumti.
For removing Gumti? Yes. Clearing the common passage.
Yes.
Lordship, can you please adjourn for the day? Then, in that case, I will produce the order in the next date.
The order is of the year 2023 November. We are approaching November 2025.
Lordship.
And when the matter is taken up, you seek adjournment. When will the matter be heard?
No, I have the instruction, but
then produce it. If you have it, and you keep it inside your pocket and you do not show it to the court, then what will the court do? Yes? Are you aware of any criminal proceedings?
No, my lord.
Nothing?
Never, my lord.
Submission is that there is a criminal revision
Pending
application?
matter. If there is any criminal case pending, why should I file this contempt application, my lord?
No, contempt was filed long ago. When was the order passed by the criminal court? Give me the date or the number, something.
If anything, my lord, kindly ask him to provide.
That's for the reason I'm asking for urgent.
Learned advocate representing the contemptor is not prepared. Stop. List on 6th of November. Service is taken on record. Affidavit of compliance shall be filed on the urgent date. Yes.
In this matter, your lordship directed that for actually repairing of certain portion of the shop room. So, my lord, regarding that civil matter and also in your lordship's order also direction was there that we will not enter into the civil matter. So we, my lord, under 411, here is the report. So for that, this order has been already communicated. Now, this may be taken as compliance.
411(1) has been served upon the owners and occupiers. Repairing work may be carried out in terms of the conditions laid down in the notice. Where is the notice? Oh, achha. To demolish the endangered portion, to secure the rest portion. Did you serve this?
My lord, yes.
Show me the service.
I am informed that
None appears on behalf of the petitioners at the time of call. Stop. Learned advocate representing the corporation relies upon the report signed by the engineers of the corporation on 6th August 2025. Stop. A notice under section 411 within bracket 1 of the KMC Act 1980 addressed to the owners / occupiers is annexed thereto. Stop. There is no proof of service of the said notice upon the owners / occupiers. Stop. By the said notice, the owners have been directed to take steps for demolishing the endangered portion / ruinous state of the building and to secure the rest portion of the existing building. Stop. Let a copy of the report be forwarded to the learned advocate representing the petitioners, released next Thursday, under the heading to be mentioned, so that it can be finished.
In the first page that is there, indication is there. I hope and trust that official will not telling a lie before your lordship. The second line of the first report, my lord.
Yes.
That is the my lord.
Served, but there is no proof of service.
That is that.
I had that proof been there, I could have disposed it of. You forward a copy to the learned advocate so that it can be disposed of. Call the next one.
My lord, I beg to appear, my lord.
Yes.
That's the second time, my lord. Nothing has been, my lord.
Who is the contemptor?
Pradhan and the Panchayat Samiti.
Panchayat Samiti.
Because the nature of the construction, my lord's order is.
How big? How big?
How big it is to be ascertained by both the authorities.
Oh, you do not know what is the name?
My lord, I cannot measure it. My lord's order is there. Second page, my lord.
Construction of a water body.
Over the water body. And my lord will finally come to page 52. After the order is being communicated.
Yes.
My lord, kindly come to page 52 of the complete contempt.
Hmm.
They asked in a Salisi Sabha. In the present, and my lord, we are being pressurized to withdraw this matter. This is the factual condition. Page 52. May I read for my lord?
No. None appears on behalf of the.
My lord, I am for the Pradhan, my lord.
What is your submission?
My lord, I held meeting several times, my lord.
Yes.
There is a, my lord, kindly see the meeting resolution.
Tell me what is there. Dekhi.
Kindly see the resolution.
Yes. Tell me what is there.
Several times, my lord, I held meeting.
Yes.
The petitioner cannot appear at that time of hearing, my lord.
Petitioner is not appearing.
No, my lord.
You are threatening the petitioner to
No,
withdraw the
my lord.
contempt.
No, my lord. No, my lord.
Sure.
Sure, my lord.
What is this notice at page 42?
My lord, kindly.
53. Okay, which page?
52.
52.
Who are these persons? Why these persons are required?
Why do you want this Shalishikaner upostitite this is to be resolved? Why?
My lord, kindly see the next my contents, my lord. This
Page 50. You have the copy?
No, my lord.
Page 52 of the contempt.
It's 52.
Very well.
In the middle of the page.
My lord.
নিম্নলিখিত সালিসিগণের উপস্থিতিতে. Why?
My lord, they are the member.
Member of?
Member of Gram Panchayat, my
Gram
lord.
Panchayat. Yes. What you are what is your contention over here?
My lord, I several times request to appear.
Could you identify the structure which has been alleged to be constructed unauthorizedly?
My lord. My
has it been constructed over a water body?
My lord, there is a construction
over the water body?
No, my lord.
Not over the water body. Where is the
There is
construction?
Dokan. Conclusion Dokan, my lord. Classification Dokan.
Dokan where? In a water body?
No.
Where?
My lord, already, my lord, it is annexed with the writ petition.
It's annexed with the writ petition. Which page?
It's a permission paper, my lord.
Page
There is a
35.
permission paper.
Page 30?
35.
Page 35. Show that photograph to him. Does it look like a dokan?
My lord, beside the pond, my lord.
Beside or encroaching the pond?
No, my lord.
No.
No, my lord.
Photograph speaks, my lord.
Is this a dokan?
No, my lord.
Then what is it?
This picture is another picture, my lord.
Another picture. What is the proper picture? Show me.
My lord, I pray for time for next week, my lord. Kindly arrange it.
What does this report say? This is March 2024. We are in September 25. What happened thereafter?
Thereafter, several notices are there, my lord.
Several notices are there.
My lord, kindly see. Several dates and several notices, my lord. Lastly, I plucked that notice.
What to do with these pradhans? The court is just fed up. Please come. The order of the court has not been complied with. Stuff. The learned advocate representing the pradhan. Did you file your vakalatnama?
My lord, I filed vakalatnama.
You have?
My.
Shailesh, please check. Submits that several notices of hearing were given to the petitioner, but the petitioner is not appearing in the hearing. Stuff. The aforesaid contention of the pradhan is disputed by the learned advocate representing the petitioner. Stuff. It has been submitted that submitted that unauthorized construction over the water body still remains. কোথায় contempt এ? Contemptor 1 and 3. What is your name? What is your name? What
My
is
lord,
your name?
Mr. Taraknath Sarkar.
Taraknath Sarkar. ঠিক আছে। আচ্ছা। ঠিক আছে? Hearing of the contempt application stands adjourned till 13th November 2025. Stop. The contemners are directed to conduct a spot inspection upon prior notice to the petitioner and place the spot inspection report before this court on the adjourned date. Stop. Photographs of the unauthorized construction shall be produced by the learned advocates representing both the parties on the adjourned date.
Fine.
Let us see whether it is a dokan or a big building.
Fine.
And whether water is there or not. All right.
My lord,
Acha.
may I get the copies of the documents?
What are these? You want to this to be filed or you want to keep this with you?
My lord, I want to keep file. My lord.
File it by way of affidavit
Fine.
so that he gets a copy. Service ta rekhe din. Call the mentioned matters.
My lord, affidavit of service.
Yes, yes. কাগজটা ফেরত দিয়ে দিন. Call the mentioned matters, please.
Item number 238.
Lord, I am the petitioner.
Has the order been complied?
Lordship.
Learned advocate for both the parties submits upon instruction that the order passed by the court has been complied with.
Okay, may I file the?
Yes. In view of such submission, the contempt application stands disposed of. The instruction forwarded by the Special Secretary. Special Secretary, which department? UDMA.
Joint Secretary signed this letter.
Joint Secretary.
The order has been the last page. is
Last
signed.
order is Joint Secretary. The report is by the Special Secretary. Achha, by the Special Secretary.
UDMA, Urban Development.
UDMA and the annexing copy of the communication of the Joint Secretary UDMA dated 2nd September 2025 be retained with the records. Disposed. Yes.
I appear for the petitioner. Yeah, my lord, your lordship's order passed in the writ petition.
সামনে দেখুন দেওয়া আছে নাম দিয়েছে তো? Yes.
Kindly, my lord, see, my lord, page 12 of my application, can number 2, can number 1. Can number 1. Your lordship directed the administrative secretary.
Yes, what is your submission?
My lord, just a minute, my lord, I'm telling you, lordship. My lord, on the last occasion, they submitted that the finance secretary too passed an order, my lord, treating my that period unauthorized action period as dies none, that is breaking service. But your lordship's direction was that this the administrative secretary should forward my application for taking decision to the
Governor.
honorable governor. They have not done so. On the other hand, the governor, the finance secretary has passed an order which goes against me. My lord, your lordship, by the order dated, my lord, 24th of July 2025, kindly see.
Yes.
24th of July.
I have seen that.
My lord, there, my lord, your lordship directed the administrative secretary
been
to
regularized.
second. No, regularized by treating the same as dies no. That is breaking service. That is breaking service.
Was it forwarded to the governor as per the regulation?
Milord, whole difficulty is this, Milord, I am go up to Contempt secretary, thereafter special secretary, and then chief secretary. It was Dr. Pont. Which was sent to him by our secretary. Milord, thereafter,
Question is this, my
I
lord,
am
the
really in trouble.
finance secretary cannot pass this order.
No intention, my lord.
My lord, finance secretary,
order that will be
my lord,
complied by me.
your lordship, kindly
Petitioner
bear
is
me for a
agreed.
moment. My lord, finance secretary
Petitioner
order
is
goes against
aggrieved
me.
I have
by
no
the
intention.
decision taken by the Additional Chief Secretary Finance Department
Which is no
on
association to
11th September 2025 by treating the period of absence of the petitioner as dies non. Stop. According to the petitioner, the Additional Chief Secretary Finance Department does not have the authority to pass such order. Stuff. The court is of the opinion that the order passed by the Additional Chief Secretary Finance Department gives rise to a fresh cause of action. Stuff. It will be open for the petitioner to challenge the impugned action of the authority before the competent forum in accordance with law if so advised. Contempt application stands disposed of. Call the next matter, please.
My lord, that it has not been forwarded to my lord, that is the way.
Yes.
Yes, my lord. I appear on behalf of the petitioner, my lord.
Yes.
Your lordship, kindly come to page 61, your lordship's order.
Lord, I am for the contempt, my lord.
Uh,
My lord, in this record, my lord.
Page 61.
Page 61 of my petition, your lordship's order, dated 5th of March 2024.
Yes.
Then your lordship, my allegation was that the
Board of Councillors, Kanchrapara Municipality to consider and dispose of, spot inspection and everything. What happened?
And at the last paragraph, the municipal, page 2.
Yes, the open drains.
That the open drains are covered to stop breeding of mosquitoes.
Right, right.
But for the last 1.5 years, my lord, after communication of this order, I went on submitting representation and ultimately the contempt notice. Till date, drain has not been covered up. No hearing, no order.
My
And
lord,
my day by day is miserable.
All right.
my lord, the proceeding is already been started, my lord. I have required to only 3 or 4 weeks times, my lord. In the meantime, I'm
Proceeding started. It was in March 24.
my lord, kindly, my lord, I have not, after receiving the contempt notice, I came to the about the order. They have not supplied me any such of order. They have completed later only. I have not. No, kindly see for a moment. Page of the complaints letter, page 65. There is no order. Only
There is no order. The case number is mentioned over there.
yes, but the order is not supplied. I came to. I have received the order from the content application itself, my lord. And I'm
The
duty
order
bound-
date is there.
Yes, my lord.
The order is there in the public forum. It is available in the server. Nowadays, everything is very transparent. You cannot keep orders inside somebody's pocket.
My lord, that is true. That is
Then
true. I am duty bound to.
you are duty bound to comply. When will the drains be?
Inspection is been over, my lord. Kindly give me 2 or 3 weeks time. In the meantime, I'll communicate this order, my lord.
But not only
I'm
the
ordered-
order, I have
I'm
also
ordered before
submitted
your
its representation, which has been directed to be
Very well, I will
considered.
comply. Yes.
But 2-3 weeks, my lord, I am suffering for the last 1.5 years. My lord,
Learned
let me
advocate.
cover up the drain.
Learned advocate representing the Kanchrapara Municipality / Contemner seeks time to comply the order passed by the court. Stuff. It appears that order was passed by the court on 5th March 2024, directing the municipality to ensure that the open drains are covered to stop breeding of mosquitoes and other insects, to prevent spread of vector-borne diseases. Stuff. The same has not been done till date. Stuff. Because of the ongoing monsoon, the petitioner submits, that there is breeding of breeding of mosquitoes and other insects, which is spreading disease in the locality. Stuff. The municipality.
Of the drain, my lord.
The overflowing of the drain is creating nuisance in the area. Stuff. The municipality is directed to take immediate steps to cover up the open drains. Stuff. Let a compliance report acting in terms of the order dated 5th March 2024 be placed before this court on the returnable date released 13th of November.
Obliged, my lord.
Affidavit of service is taken under. Did you file your wakalatnama?
No, my lord. Today morning, I have received this copy, my lord.
Please do file wakalatnama. This is a contempt matter.
Before the department, my lord.
Please, before the department.
Yes, I will.
Leave to file wakalatnama. By tomorrow, file it.
By tomorrow. I have received, but it's not.
Leave granted to the learned advocate representing the contemner to file kojonate taken neben ekjon na dujon. Wakalatnama in the department by tomorrow.
By tomorrow.
Yes. Ar nei to?
I'm grateful. First time service, my lord.
No, it's already.